Good morning, everyone. My name is Stacey Robertson, and I am so happy to serve as the president of Widener University. I wish that I could be there with you this morning to participate in this really incredible symposium that you are a part of today, Legal Obstacles in Addressing Gender-Based Violence. This is such an incredibly important topic. You have a wonderful featured speaker in the Honorable Kevin R. Steele, District Attorney of Montgomery County. I would love absolutely to be there with you today, and I know you're going to learn so much and you're going to have such a great experience. Our students and faculty at Commonwealth Law School are so phenomenal and so dedicated. And again, this is such an incredibly important topic. I'm delighted that you are there, that you're learning. I just wish I could be with you. Have a wonderful day, and thank you so much for joining us.
Good morning, everyone. My name is Jessica Poley, and I am the Pennsylvania Law and Symposium Editor for the Widener Commonwealth Law Review. I am honored and excited to welcome you today to our Spring Symposium, Legal Obstacles in Addressing Gender-Based Violence. Every year, the Law Review holds our annual Spring Symposium on varying topics in the law. I am grateful to have been able to plan such an amazing event with such an incredible group of speakers, a supportive administrative staff, and a wonderful law review team. This topic is one that I am very passionate about. It's been the topic I wanted to pursue since I interviewed for the position of Symposium Editor. And I'm grateful to have been selected for this position to be given the chance to bring this amazing event to life with the Law Review. Gender-based violence is a difficult topic to discuss. But the unique advantage of having a symposium like this is that we at Widener and in the Law Review can provide a platform for these difficult conversations. I thank you all for coming and spending your Friday with us to have these much needed conversations. Before we begin, I would like to thank all of the people who helped make this event possible. Without these people, I would not be able to stand here before you today presenting our Spring Symposium. First, I would like to thank Dean Cummings for his support of the Law Review and our events this year. His belief in us and our messaging means the world to me and the entire Law Review. I would like to thank our Law Review advisor, Professor Kearney, and our editor-in-chief, Miranda Thompson. They have supported me through planning this event every step of the way. Their input and involvement was crucial to making this event a success. I would also like to thank our wonderful client experience team, Brian Fernbaugh and Rob Brown, for their IT support throughout this process, and especially today during the symposium. Thank you to our moderators, Professor Buchhandler-Raphael, Dean Teplitz, and Dean Antos, for their passion for this topic and for coordinating the panels you are about to see today. I want to again thank Dean Teplitz, as well as Dean Ackrey, Stephanie Engerer, Paula Hyder, John McCafferty, Val Hawkins, and Jeremy Wingert. They are an amazing and dedicated administrative staff who supported us in booking arrangements, catering, advertising, obtaining CLE credits, and much more than I have time to list today. I am incredibly grateful to our entire Law Review board and staff for their support of this event, and especially for their help throughout today. And a special thank you to Riley Stoltenberg, for our business external managing editor, for her help with posting about the event continuously on our LinkedIn page. Thank you to our amazing speakers, who are all taking their time to come speak to us and be a part of this important conversation. And last, but certainly not least, I would like to thank Professor Buchhandler-Raphael again. She has worn many hats for me during the planning process of this event, and even today. She is here as a speaker, a moderator, and she helped me develop my broad topic into one that was specific enough to be used to put on a symposium. She also helped me find many of the speakers here today. Professor Buchhandler-Raphael and I share a passion for this area of the law, and she has been invaluable in making this rough idea into the amazing event we have planned for you all today. Thank you, Professor Buchhandler-Raphael. And thank you all for coming here today. It means a lot to me, and I am very excited for what we have planned. Before I introduce our first panel and moderator, I would like to highlight the format of the panels. Each panelist is going to present their work one after another. I ask that questions be saved until the end of all presentations, where we will then have a 15-minute Q&A session. Questions during the Q&A session can be directed to any panelist. There will be 2 Law Review members walking around with microphones at that time for you to ask questions. We also ask that you try not to leave in the middle of a panel. There will be a 15-minute break between each panel if you need to leave the room for any reason. With all of that being said, please allow me to introduce our first moderator for the sexual violence panel, Professor Michal Buchhandler-Raphael. Professor Buchhandler-Raphael is a tenured associate professor of law at Widener University Commonwealth Law School. She has written extensively on the criminal justice system's treatment of sexual offenses. She argues that sexual crimes are under-enforced and under-prosecuted, advocating for a more equitable consideration of victims' interests. Her scholarship also critiques the law's heavy emphasis on consent in cases involving abuse of power within professional and institutional settings, as well as its inadequate protection of voluntarily intoxicated sexual assault victims. Please join me in welcoming Professor Buchhandler-Raphael.
Good morning, everyone. Thank you so much for being here on a Friday morning. First of all, I would like to thank Jessica Poley for her amazing work, phenomenal work she has put into organizing this symposium. She was hugely successful in bringing together nationally renowned scholars in the area of domestic violence, and amazing practitioners, and of course the Honorable DA that we're gonna listen to in the afternoon. So really, I cannot thank Jessica enough. It is my pleasure and my honor to introduce Professor Ben McJunkin, who is an associate professor of law at the Sandra Day O'Connor College of Law at Arizona State University in Phoenix, Arizona. He is also the Associate Deputy Director of the Academy for Justice at Arizona State University Law School, as well as an affiliated faculty member with the School of Criminology and Criminal Justice. Professor McJunkin teaches and writes on topics in criminal law and criminal procedure. His scholarship focuses primarily on the criminalization of sexual violence, the treatment of sex offenders, and the criminalization and policing of unhoused individuals. His legal research frequently connects doctrines with broader themes in moral philosophy and gender theory. During law school, Professor McJunkin was the editor-in-chief of the Michigan Journal of Gender and Law. Following law school, he clerked for Justice Peter J. Rubin on the Massachusetts Appeals Court and Judge Kermit V. Lipez on the United States Court of Appeal for the First Circuit. Professor McJunkin's recent and forthcoming scholarship has been published in the California Law Review, the Michigan Law Review, the Virginia Law Review, and the Cornell Law Review, among many, many others. Please join me in warmly welcoming Professor McJunkin.
All right, good morning, everyone. I'm really excited to be here with you today. Thank you for Jessica for extending the invitation. I like to walk and talk, so I'm going to move around a whole bunch. And I've got a little presentation for you all. Just to put this in perspective, my background is in moral philosophy. My expertise is in substantive criminal law, so particularly given this task of engaging with the legal obstacles of gender-based violence, what I'm interested in thinking about are the elements of the crimes that we most identify with gender-based violence. And so the focus of my presentation today is a distinction between harm and wrongdoing in the law of rape that I think is important for us to understand. To give you a brief overview of what I'm going to be talking about today, I'm distinguishing between harm and wrongdoing because I think that our current criminal law undersells instances of wrongdoing, that it fails to capture all of the wrongdoing that accounts for sexual violence. And I think that a large part of this is because of the rise of consent and our overfocus on consent as the central element of rape law. I'm going to highlight today some attacks on consent that I think have been studied, under theorized, and not taken quite seriously enough, and showing the way in which our emphasis on consent might be fueling backlash that is detrimental to women everywhere. I'm going to also talk about sort of the fundamental failures of consent, or the challenges that come along with having a consent-based rape law, as a general critique of the idea that consent should better be understood as an aspect of rape law's harm rather than an aspect of rape law's wrong. And this will open the possibility that we can criminalize more wrongs besides just non-consensual sex. and indeed that we can criminalize some consensual sex is nevertheless wrong. Right. The second half of my presentation, I'm going to emphasize the ways in which we could restructure rape law to center wrongdoing. Right. First, by making rape a result crime, similar to the crime of homicide or aggravated assault, where the focus here is on particular means of causing a harmful result, rather than on the intended circumstance of consent itself. In my work, I usually use the idea of human dignity as a basis for understanding what precisely is wrong with rape. I like human dignity, the Kantian version of human dignity particularly, because it's all about objectification and instrumentalization, the way in which we use people as means or as objects, rather than treating them as full human subjects who are capable of their own decision making. Right? I'm going to offer a couple model statutes. One is mine, a proposal that I have in a piece in the Cornell Law Review. The other is actually the recent revisions to the Model Penal Code, which hasn't yet been adopted anywhere, but that actually adopts a lot of the structures that I've been advocating for over the last few years. Okay? And then I'll talk briefly about potential limitations of following my approach, some of the drawbacks that might exist. But I hope that this will get us thinking about expanding our approach to rape law and understanding that there's much more wrong besides non-consensual sex. Let me start with consent. Right? At common law, rape consisted of three elements. Right? This is the Blackstone definition of 1765. It was carnal knowledge that is sexual intercourse, right, of a woman forcibly and against her will. Against her will is a synonym for non-consent. Right? So traditionally required sexual intercourse by force and without consent. Okay? Really until about the 1950s, this definition was unchanged. It's still the dominant definition. For the majority of states, forcible sexual intercourse without consent is the definition of rape. Right? But that's starting to change. Right? Among other things that have changed, we can now acknowledge male victims. They used to be rape was only a crime that can be committed by males against females. Now it is a crime that applies to everyone. We've expanded the prohibited sex acts, which allows intercourse, oral sex, other kinds of sexual touchings, or sometimes groped under the language of grappled under the language of rape. But also, one of the big changes is that we've started to emphasize consent and comparatively de-emphasize force or violence. Right? So right now, more than half of states criminalize non-consensual sex in the absence of force. My last count, I think it's 36 states have a crime of non-consensual sex with no force or violence. 22 of those states make it a felony, right? The equivalent of rape. The other 14 states make it some sort of lesser sexual crime and reserve the label of rape for forcible sexual intercourse. Right? There's 20 states. Okay. One of the things that my research has revealed is that not only are we increasingly defining rape strictly by definition of non-consensual sex, but also even in jurisdictions that retain a force requirement, our emphasis of the crime of rape is focusing on what the victim did rather than the wrongful conduct of the offender. So let's start with the force requirement. Right? In jurisdictions that have a force requirement, there typically is no definition of how much force is necessary in order to effect the crime of rape. Rather, what those jurisdictions require is a certain amount of resistance by the victim to manifest her non-consent, and then the sexual penetration by overcoming that resistance is evidence of force. And so rather than give us a quantum of force that can be identified as rape, what we look to is, did the victim resist enough? Different jurisdictions have different standards. It used to be that resistance was required to be to the utmost, which is effectively a physical fight, sometimes to the death. And now the standards are usually something like earnest resistance or reasonable resistance. But nevertheless, the standard is still what the victim does. And so the focus of our rape trials is on the victims fighting back rather than specific wrongful conduct by the defendant. Okay? Also, a traditional rape law was a general intent crime. Okay? As a general intent crime, it didn't require much inquiry into what was going on in the defendant's head. Right? Typically, the sexual intercourse itself was not an accident. Typically, the use of force was something the defendant was aware of. And there was no requirement that the defendant knew that the sex was not consensual. But starting in about the 1960s, that began to change. There's a mistake of consent defense the common law jurisdictions have adopted. And the mistake of consent defense asks the question about whether the defendant was reasonably mistaken about whether his partner consented. Okay? And that would operate as a full defense to the crime of rape. However, the way in which that becomes structured, again, focuses on the actions of the victim, right? That is, given her outward manifestations of non-consent, would it be reasonable for this defendant to have concluded that there was consent, right? And ambiguity is generally construed in favor of the defendant, right? That is, in fact, some jurisdictions even ask the question of whether any reasonable defendant could have interpreted this as consent, given the outward manifestations of the victim. And so the focus again on our trial, even when it comes to a question like mens rea, which is usually focused on what's happening in the defendant's head, is really a focus on what the victim did so that we can interpret from that whether the defendant was reasonably mistaken. And then non-consent is its own standalone element. And as an element, it is very confusing. It's confusing in part because almost no jurisdiction defines consent in rape law. There's all sorts of debates about what consent is and how it operates, and the statutes don't make that clear. And so again, right, even in jurisdictions that require force, because force and non-consent are separate elements, we can find that a particular defendant used force and nevertheless conclude the sexual intercourse was consensual, right? And we have cases that look like this, where juries have actually come to the conclusion that despite the use of force, despite the use of weapons, I have one case that I'd like to emphasize that happened in Texas, where a man broke into a woman's apartment and held her at knife point, right? And the jury concluded that she consented to the sexual intercourse that happened after that, right? So because these are separate elements, right, the presence of force itself does not render the act rape, right? But rather the presence of force only opens the question of whether there was some subsequent consent. Right. Socially, I think we're moving farther and faster than the rape laws actually move, right? When I talk to my students about rape law, they are blown away, right? At how narrow and limited rape liability is. Because they were socialized in an environment probably not unlike this one, where colleges tell them actually consent is everything, right? And in fact, that what we're teaching students these days is that consent itself is not only the line between criminal and non-criminal sex, but it's the line between good and bad sex, right? The consent is somehow inherently valuable, and that should be the centerpiece of everything, right? Over the last few years, really 2 decades, we've also come to the conclusion that consensual sex is constitutionally protected, thanks to Lawrence v. Texas, right? Question about whether that will remain on the books with the current court, right? But what's interesting about that case is that in fact, there's no evidence in that case that there was consensual sex, right? There's no evidence in Lawrence that the sex was consensual. The court presumes that the sex was consensual, and then interprets that consensual sex as constitutionally protected, right? And as I said, right, colleges and universities are educating students on the merits of enthusiastic consent, right? The University of Wyoming says something like, right, that consent is not only necessary, but in fact it's sex. Right? Colleges will tell students that consent is foreplay. Consent becomes an integral part of a good sexual experience. And I think this is actually detrimental to us in a lot of respects. I think it's detrimental to us in part because there's lots of bad sex that's happening that's nevertheless consensual legally. Okay? Another reason I think it's bad for us is that these social narratives are spurring attacks on consent. And these have been massively understudied. I don't think people take them seriously. But I want to emphasize first on what the nature of consent is, right? So conceptually, sexual consent is understood as acquiescence to pursuit, right? So one party is initiating sexual intercourse, the other party is to say yes or no. Okay? And in our society, pursuit is coded as masculine. Right? The gatekeeping, that is saying yes or no, becomes coded as feminine. And we're socialized into this, right? I do some research on sociologists who have studied the idea that young men are taught to try to get sex, and young women are taught strategies to try to defend against men getting sex. Right? That this becomes part of our gendered understanding of how sex occurs. Right? And in fact, this fits with our understanding of rape law as primarily a gendered crime. In my scholarship, one of the things that I argue is, in fact, this pattern degrades cross-gender relationships, because what it does is it teaches us the other person, rather than a source of connection, rather than another human being that we're engaging with meaningfully, is in fact an opponent, right? That if I'm trying to get sex and you're trying to stop me from getting sex, we're not doing this together, right? And in fact, I'm trying to overcome your will in some sense. I'm trying to overcome your resistance. And I think that's detrimental to us, right? So the very frame of consent, I think, is detrimental to thinking about us. But I think what's worse, right, is that the frame of sexual gatekeeping has been used by some to justify violence against women and to justify patriarchal interventions, right? So the idea here is that there's a sort of manosphere, right? A group of men online that have adopted ways of thinking about sex that embraces this notion that sex is a matter of choice, right? Which consent teaches us. Consent is about sexual autonomy is about choice, right? And consent is a matter of choice, and that women actually operate primarily as sexual gatekeepers because men are constantly pursuing sex, right? Then what we find is that men are starting to push back on the idea of choice altogether. There's a number of incels, right? Involuntary celibates, if you're not familiar, right? Who leverage precisely these narratives to justify violent attacks against women. Over roughly the last decade, there have been 6 mass murders killing 50 women. Just based on the sort of incel movement, right? The idea that people who aren't chosen for sex should somehow be righteously angry at the women who are denying them sexual access. Right? And the incel violence has motivated other notable men's rights proponents. In the paper that I'm writing for this symposium, I highlight the work of Jordan Peterson, right? Jordan Peterson says the solution to incel violence is enforced monogamy. And what we need to do is deny women the ability to make sexual choices, right? Because that's the source of power that women have over men. And then instead, we should try to pair everyone off so that everyone has access to sex, right? And Jordan Peterson might sound like an outlier, but in fact, that notion of enforced monogamy has been picked up by New York Times columnists, by economists, and I've seen at least 2 peer-reviewed studies that have been published in academic journals exploring whether this is a reasonable phenomenon. In the same way we might redistribute income, we can now redistribute sex by denying basic autonomy. And I think this all stems from our focus on consent, right? Those social narratives that sex is all about free choice are social narratives that perpetuate this kind of violence and this kind of backlash against women as a class. I also think that consent, philosophically speaking, is simply too nebulous to be a good source of criminal law. One of the things that we don't get into in criminal law, but we really need to, is whether consent is subjective or objective. Most states, based on their jurisprudence, seem to think that consent is subjective. It's a thing that happens in the individual's brain rather than an outward manifestation, a thing that they do or express. There's also 2 ways of thinking about consent, right? Historically, we've thought that consent is present unless evidence of non-consent is absent, unless evidence of non-consent is present. Right? More recently, we've started to think that non-consent is our baseline, right? Unless evidence of consent is present. And again, the evidence, right, is a question of whether we're trying to figure out what the person did or what the person is thinking. But the more we try to get into someone's brain, the more likely juries are to make mistakes, to impute consent on people who didn't actually willingly participate. There's also a big question about consent and the conditions for legal validity. When we talk about consent, we assume we all know what it means, right? But when is consent valid in the face of deception? Almost always, in fact. Right? When is consent valid in the face of extortion, threats, blackmail? Almost always, in fact. Right? It is typically the case that consent is considered invalid in the face of force, but even then, I give you the Texas case, right? There are cases where juries have found even the presence of force doesn't invalidate consent. This is an area of philosophical inquiry that needs further exploration, but our jurisprudence suggests that consent is actually very resilient. That consent is considered valid in the face of all these. And in fact, this is widely shared, right? Rosanna Summers at the University of Michigan did a study where she found that just asking people whether consent to sex was valid in particular circumstances, they found that consent is valid despite things like material deceptions. And if somebody says, I will only have sex with you if you're not married, and the person lies and says, I'm not married, even though they are, consent is valid. And that's a commonly shared perception. And so the law reflects that commonly shared perception, right? But that's still a situation where there's indeed wrongdoing and indeed harm, right? Then we get into the question of whether sexual autonomy, which is generally understood as the value that motivates sex, is really the right value at all, right? There's competing conceptions of autonomy, positive autonomy versus negative autonomy. Positive autonomy is the freedom to get to have sex with people that one wishes. Negative autonomy is the right to be protected from sex that one doesn't want. And in these circumstances, philosophers are constantly debating how to draw that line between giving people sufficient freedom while protecting them from harm. Right? And it's not clear that autonomy answers that question in a meaningful way. Right? Some scholars have suggested instead of autonomy, we ought to understand consent as protecting sexual agency, which is a more limited version of autonomy that doesn't anticipate that people are free, but suggests that there are meaningful constraints. But actually, the weakness of agency theory is that it still emphasizes consent at its core, despite recognizing constraints. And so what it does is it basically blinds our eyes to all of the wrongful ways in which consent may be procured. It's often the case that consent is a result of some stratagem to get sex or some stratagem to procure consent, right? And when we focus purely on the moment of consent, that's the moment of rights transfer, right? That moment of waiver, if you will. And what we lose is we lose that perspective on everything that led up to that moment and what might be wrong about that from it. There's also contested applications. Right? In my scholarship, I've highlighted the concerns about age and intoxication. We treat age, for example, as an example of invalid consent. A person under a specific age simply can't consent, we say. Right? There's no psychological basis for the age that we've drawn. In fact, it's a political compromise. Right? There were reformers who were advocating for ages as high as 21 not that long ago. Right? And we settled on ages between 16 and 18 in most states. Right? But there's no reason to think that people below certain ages can't consent or people above certain ages can. Right? We've drawn a relatively arbitrary line. Intoxication is not an arbitrary line, but it also runs into a similar problem, right? That we treat people who are intoxicated as if they lack the capacity to consent without any meaningful investigation about what that capacity looks like. What would be necessary in order for someone to make valid consent? And different jurisdictions have different standards for it. In fact, most jurisdictions have almost no standard at all. They just toss it to the jury and say, if this person is too intoxicated, you can decide their consent is invalid, that their yes doesn't mean yes. In some jurisdictions, the standard includes some language about being reasonable, right? Which allows juries to second guess the wisdom of people's sexual choices. And so in trying to protect young and intoxicated people, we often stretch our notion of consent in ways that don't actually fit with the notions of autonomy that are supposed to motivate it. On the other hand, as I've highlighted, right, cases of fraud, almost any lie is permissible under common law or law. The only thing you're not allowed to lie about are really two things. One is you can't lie about the fact that you're having sex. If you trick someone into believing that they're engaged in a medical procedure, for instance, but it's actually a sexual act, right? That's not permitted. Also, many jurisdictions have statutes that specifically outlaw impersonating someone's spouse. Right? So if you have a twin, right, don't pretend to be your twin and go have sex with their spouse. Outside of that, any law, right, or sorry, any deception, right, is perfectly within the bounds of law. And so we don't actually reach a number of frauds that might be material to people's sexual decision making. If we care about autonomy, we care about individual choice, our notions of what frauds should be criminalized are actually much broader. Same thing with non-physical coercion, right? We usually accept that you can't procure sex by violence, right? But extortion, threats, right? Including things like threats to, report someone's immigration status, to accuse someone of a crime. But even threats that are more mundane. Have you ever had a partner who's threatened to break up with you if you didn't have sex with them? Right? Those kind of extortionate threats are things that undermine people's autonomy in meaningful ways. It diminishes their ability to choose. And yet the law doesn't treat them seriously. And so, despite the fact that we seem to be emphasizing this notion of consent above all other considerations, right, we're not doing a very good job of mapping our jurisprudence about consent onto notions of individual autonomy. And from this, we get a series of critics about consent. Right? Scholars who are saying maybe consent isn't quite the right thing. Right? For one, consent maybe understate rape's harms, right? If it's just about consent, then the denial of consent is simply a denial of free choice. And that's not really what's bad about rape. Is it like, oh, you lost your ability to choose? Right? There's considerations like dehumanization and objectification that I think sound in the language of dignity, but that in fact aren't really captured by our notions of merely non-consensual sex. Right? There are also people who note that rape is typically considered a pattern of gender-based terror, right? That rape is a means by which all men keep all women in a state of fear. Right? This is a famous quote. And we're not acknowledging that either, because we're viewing rape through this individual lens. Okay. Also, I think consent insulates certain harmful sex from scrutiny. There's two ways to think about this. One is that at least some consensual sex is harmful, despite the fact that it's consensual. Right? It's harmful precisely because it's unwanted, undesired. Right? It might be the best of bad options, but that doesn't mean it's good. But also because our focus on consent, right, doesn't look at the things that led to consent. So any number of pressures, right, that might have impinged on someone's autonomy are typically obscured from view. And so once we see that sex is consensual, we treat it as if it's perfectly acceptable. And I'm not sure that that's right. Okay? Some people have proposed alternatives. Rather than thinking about rape as a matter of consent, we should analogize it to things like lynching and slavery and torture, right? It goes hand in hand with that notion that's a pattern of gender-based violence. Okay? There are other scholars who have said what we need is we need an ethic of mutuality. We need people to actually care about what's going on in their partner's mind, right? They care about whether their partner is enjoying the experience. And I think this is also, to me, sounds in the language of dignity, to treat the other person as a full and complete subject rather than a sexual object. Right? And lastly, a few scholars have suggested that in fact what we need to focus on, and I think this is the key, is not simply whether sex was consensual or not consensual, but what the means are for obtaining sex, right? How was sex obtained in particular circumstances? For this particular symposium, I want to add a couple things to some of the previous scholarship that I've written in this area. Right? So even in legal theory among philosophers, we've increasingly recognized the idea that rape is defined as non-consensual sex. Okay? And in fact, the non-consent is the exclusive wrong of rape. The thing that makes rape wrongful is that it's non-consensual. And philosophers have largely embraced the subjective account, right? That what happens, that consent is a thing that happens in your brain, and it operates like a waiver, right? You lose your right to object to sex that you don't, that you consent to. Okay? These theorists usually distinguish between wrongdoing and something called culpability, which is really a matter of the defendant's blame ratings. And so as long as sex is consensual, it's not wrongful, even though defendants may be culpable. And that creates a line that's sometimes squishy about whether or not criminalization is justified. Right? So really here, criminalization is considered unjustified as long as sex is consensual. But I think that this notion of wrongdoing is wrong, right? Or at least contestable for a few reasons. And the biggest reason comes out of what I call secretive consent cases, right? This is a philosophical exercise, so bear with me for a second, right? Consent is secretive when it is subjectively experienced. That is, the person consents in their head, but doesn't outwardly communicate it for any number of reasons. Okay. Under those circumstances, the defendant would be proceeding with sex despite no evidence that it's consensual, and in fact, perhaps even believing that it's non-consensual. And yet our legal theorists would say under those circumstances that no wrongdoing has occurred. And I think that's wrong. I think it's wrong for at least three reasons. The first is that if it's wrongful to impose non-consensual sex on someone, then it's equally wrongful to impose a risk of non-consensual sex on someone, at least when that risk is substantial. And if our hypothetical defendant proceeds with sex with no evidence that it's consensual, or perhaps even believing that it's non-consensual, then he's imposing that risk on this individual. And even though it is consensual for that individual, right, that kind of conduct, writ large, would impose a lot of harm on a lot of people. That's wrongful in itself. More importantly, from my perspective, acting for indefensible reasons is wrong. So again, a person who engages in sexual intercourse believing it's non-consensual is engaging in wrongdoing. Right? In fact, what they're doing is attempting to rape. Their attempt has failed because of the consent. Right? But their attempt is every bit as much a crime as the rape itself. And then the last thing is we think of things as more wrongful than just a violation of consent. Like the objectification of another person is an independent form of wrongdoing. And so we can build a theory of rape around these ideas. Right? What's happening in the defendant's head? Are they acting for the right reasons? And are they engaged in objectification and dehumanization of another person? Right? This leads us to the possibility that we might actually criminalize some consensual sex, at least in those secretive cases. Right? What I suggest is that, in fact, the better way to think about consent, rather than rendering sex non-wrongful, is that it perhaps renders sex less harmful. In the secretive consent case, the person who agrees to the sex mentally, right, who welcomes it, right, is less harmed than they would be otherwise. Right, so the operation of consent is not that the behavior is not wrongful at all and therefore not criminalizable, but simply less harm. Right? But even in the absence of harm, our criminal law allows us to punish people who engage in behaviors that tend to cause harm. And certainly a defendant who's engaging in a sex that they believe to be non-consensual is engaging in behavior that has a tendency to cause harm. And so I think by definition, all three forms of the argument of wrongdoing in secretive consent cases highlight the idea that even where some sex is consensual, they can be rightly criminalized. And so consent ought not be our line, but that means we need to find a new one. Right? How do we center those other forms of wrongdoing in our compensation operation? Well, my hypothesis is that what we ought to do is borrow from some of our other areas of violence. Homicide is a result crime, right? It's defined as causing death with certain specified mens rea. Aggravated assault is a result crime, right? It's defined as causing fear through the use of impermissible means, such as a weapon. Right? And so rather than asking whether a given sex act was consensual, we should ask whether a given sex act was caused in a wrongful manner. Right? These causal inquiries are very common. Criminal law is well equipped to engage in them. And if we do that, then it allows us to focus our debates on rape law about the conduct and the mental states of the accused rather than what the victim was doing under the circumstances. Right? Doctrinally, I think it has a lot of benefits. It refocuses the actus reus of rape on the wrongful conduct of the accused. Right? This is what criminal law is supposed to be doing: interrogating, right, the acts of the accused. It gives us an ability to increase mens rea. Right? As I said, at common law, rape is a general intent crime, which is effectively no standard at all. Right? But if we restructure rape law so that we're focusing on the wrongful conduct, we can associate that with particularly wrongful mental states following the model penal code. Or we might limit it to recklessness, knowledge, or purpose. All of those are subjective mental states that have some level of culpability. Also, a causation inquiry, unlike the inquiry into whether there was consent, actually allows a broader scope of inquiry. Right? The reason it allows for a broader scope of inquiry is because we can look at the entire chain of causation. Say, in fact, what behavior at what point in time is the right proximate cause of this sexual interaction? So it allows us to identify earlier in time wrongdoing that might otherwise be not in the purview of rape law. Well, then the question is, well, what's wrong? Right? What precisely are we looking at? And my proposal is that we ought to look at human dignity, right? That not just in moral philosophy, I suggested that I'm partial to Kantian versions of dignity, but law has lots of dignity. Right? In human rights law, dignity is a principle consistently invoked by courts to counteract a group-based subordination. So if you believe that rape is a pattern of gender-based terror, right, you might think that protecting the dignity of women in society is an important counteracting that particular version of group-based subordination. In U.S. constitutional law, dignity protects personal integrity. Right? You cannot compel someone to give up bodily fluids. Right? This is in criminal procedure. You can't pump people's stomachs or take their blood, right? Because personal integrity is so important. Am I running out of time? That's what's happening. All right, I'll run through the rest of that quickly. Right? In U.S. criminal justice, right, we're protecting bodily integrity and counteracting compulsion to things like fraud and coercion. In fact, human trafficking, I think, is the best example of a criminal law premised on protecting dignity. Right? Rhetorically, it's connected to the protection of human dignity, both domestically and internationally. The U.S. statutes, right, that we focus on center on compelling labor, including sexual labor, force, fraud, or coercion. And they use broad definitions of fraud, force, and coercion, unlike rape. Note also that in human trafficking, consent is not a defense. Right? It doesn't matter if you consented to engage in sexual intercourse. If you were compelled through fraud, force, or coercion, you were trafficked. And so I'm going to stop here with just one example of my model statute, right? So here's what I think, right? I think we can borrow from human trafficking laws and highlight the idea that recklessly, knowingly, or purposely causing sexual penetration or oral sex through the application of fraud, force, or coercion, defined very broadly, would capture much more of the wrongdoing associated with that. And of course, it would capture more instances of sexual violence, of harm, physical contact, right? But it would also realign rape law with the fundamental tenets of criminal law theory. It would highlight the ways in which the defendant's culpable wrongdoing leads to harmful outcomes, rather than put so much emphasis on the victim and the victim's reactions. And I think in doing so, we might disrupt some of those currents of power that are leading to attacks on consent, that are leading to attacks on autonomy, and that are leading to actual violence against women. So I'll stop there. Thank you guys very much.
So it is my honor and pleasure to introduce Lauren Marvell as Assistant Chief of Trials for the Family Protection Unit. Ms. Marvell oversees the special victims cases of Montgomery County. Ms. Marvell oversees a team of specialized prosecutors who work closely with her multidisciplinary teammates to deliver just outcomes in complex cases through their teamwork, collaboration, and the implementation of innovative protocols. Ms. Marvell began her career in the office as an undergraduate intern in 2010 and has remained in the office ever since. Ms. Marvell became an assistant district attorney in 2015 upon graduating from Villanova Law School. Before being promoted to Assistant Chief of Trials in 2022, Ms. Marvell served as a prosecutor in the Juvenile Division in the Family Protection Unit, and then as the captain of the Pottstown Community Protection Unit. In addition to a number of homicide prosecutions, Ms. Marvell has led the prosecution and supervision of hundreds of special victims cases, including child abuse, domestic violence, sexual assault, elder abuse, and animal cruelty. Ms. Marvell has presented across Pennsylvania to law enforcement officers, prosecutors, and child welfare professionals on the topics of animal cruelty, the use of forensic nurses at trial, investigation and prosecution of strangulation, and successful investigations of child sexual abuse. Please join me in warmly welcoming Ms. Marvell.
Good morning. Oh, thanks. There we go. I heard one. All right, folks. That's correct. My name is Lauren Marvell. I am a what you call a career prosecutor. And I am delightfully uncomfortable today because I was a sociology major in my undergrad experience, and the first lecture and then preparing for this presentation really in a really wonderful way brought me back to why I started this work, and to take a moment to check in with myself about how I do my work and whether I'm living up to what I set out to do. So I'm very uncomfortable in a wonderful way, and I'm grateful for that opportunity. I wish I had like a couple days to really think about that first lecture because it really landed with me. So I want to talk to you a little bit about why I got into this. When I was an undergrad, I started to get interested in the work of prosecuting or working against violence against women. And I was the first person that a dear friend told when she was raped. I sat with her when we called the police. I sat outside the little curtain when she got her forensic exam. I sat outside the police department while she gave her statement. I testified in the conduct hearing and was with her when he was found not responsible. And maybe most impactfully, I sat with her in the student union when she told me that the prosecutor was not going to take the case for prosecution. That experience impacted me in two huge ways. Number one, and most importantly to me, I learned about the resilience of survivors of sexual assault. And that is the thing that gets me out of bed every day. That is the thing that keeps me at my desk later than I would like and later than my husband and kids would like some nights. But it is the thing that motivates me to keep working even in trauma. The second thing was the power of a prosecutor. The power to take a case, whether it's difficult or not, and the impact on everyone when you make that decision as the person making a charging decision. And also, even when you choose not to take a case, the power of a prosecutor to communicate to someone their dignity, their worthiness, their autonomy. Because her experience was that she met with the prosecutor and whatever he thought that conversation was, what she took from it was that it would be a tough case to charge. They'd have to work really hard to get a misdemeanor. And when he got cancer, he didn't let it get him down. She can't let this get her down either. Fuck that, right? I can do better than that. I don't know how great I can be, but I know I can be better than that. And so I set out to be a prosecutor. So in an act of incredible discomfort to get ready for today, I looked at my personal statement from when I applied at Villanova, because I wanted to see if I was living up to the prosecutor that a young sociology graduate wanted to be. And I said in my personal statement, the disbelief, betrayal, and hopelessness that I saw in her that day, when she told me her case wouldn't be prosecuted, is what motivated me to become a sex crimes prosecutor. Not every survivor will feel comfortable telling her story, let alone pressing charges, but I am committed to becoming a prosecutor to advocate for those who do. And so now, as I come up on my 10 years and hopefully some public service loan forgiveness, I revisit myself, you know, that meme, meeting your younger self for coffee, to see how I'm doing and to reflect. So, the statistics on charging. I'm going to ask you to pop out your phones real quick. Hold on. And I'm going to stop the presentation. Whoa, I stopped the sharing. No, share the screen. Back to that. Okay. All right, you guys are going to get a free answer on this one, I suspect, because I can't turn off the show the right answer number. Close your eyes. Close your eyes. All right, now you can open your eyes. I know you all followed instructions. Okay, you can use the QR code or you can go to menti.com. There's more than one of these. It's worth it to keep your phone out for a minute. And if you're going to menti.com, you can enter a code, but it's covered by the little share button. So use the QR code if you can. And I'm going to ask you to answer across the country of percent of reported crimes of sexual assault, the cases that are reported to police, what percent are charged? This is good. You guys are good at following instructions. 42 responses. Look at you go. All right. All right, we ready? 16%. Okay, not great. It's not great, guys. Oh, come on, man. All right, pretend you didn't see it. Percentage of robberies that are charged across the country. Because I look at this and I'm like, holy cow, what are we doing, right? We are not charging any cases of sexual violence. I'm calling Menti later today because it's not user error. I assumed looking at this that the percentage of robberies reported would be super high of those that are getting charged. I was thinking like 70, 80%. The answer is 27% when you look at these statistics. So, I mean, it's still significant, right? 16 to 27% is still huge. It is a problem. It is not good. And we have work to be done. And there is a whole day of lecture that we could use to go into the reasons why we're looking at those numbers. But it did give me a little bit of a moment to say, all right, okay, we're working with something here. So, sexual assault cases, this is all from RAIN, 16% of cases that are reported, according to the study, of sexual assault are leading to an arrest. Of those that are charged, and I'm terrible at math, but I believe I did this right. Of those that are charged, 56% are leading to a felony conviction. About 50% of charged cases are leading to incarceration as a sentence for that felony conviction or conviction. And 89% of felony convictions are resulting in incarceration. So once we get over that charging threshold, we're not doing terrible, if I'm honest, because we're seeing 56% of cases being charged resulting in a felony conviction. Depending on the conduct, a misdemeanor resolution is not always going to be super offensive, depending on a number of circumstances. And there are a lot of considerations that come into play, and I'll talk about those. But once we get to that point of conviction, we certainly know that when we get in front of a sentencing judge, when prosecutors are negotiating plea deals that involve incarceration, 89% of felony convictions are resulting in incarceration. How do we do when compared to robbery? Of the cases that are reported, 27% of cases are leading to an arrest. 13% of the cases that are charged where there's an arrest are resulting in a felony conviction. So it's actually much lower, not wrongfully. 12% of the charged cases are resulting in an incarceration, and 90% of the felony convictions are resulting in incarceration. So kind of comparing, right? We've got a lower percentage of cases being charged of sexual assault. Of those that are charged, a much higher outcome of felony convictions. And then incarceration, we're having a higher outcome of charged cases landing in incarceration for sexual assault versus robbery. And then the felony convictions are almost even. I did this to kind of check myself a little bit, right? To consider how we're doing. And I would love to spend time going into why we look at these outcomes, why we see them. I don't have the data for it. That's something that maybe the next time I sit down to write something I can dive into. But what I do know is that when we're looking at charging a case, the legal requirement is that we have to be able to show probable cause to make an arrest. However, the real life requirement is that if you're going to put a case in front of a judge or jury, you need to be able to prove your case beyond a reasonable doubt. And one of the most difficult parts of that is proving not the narrative and the experience that the survivor comes forward and tells you about, but proving the elements of the crimes that we're working with. Again, I wish so much that I had had a little bit of time to like marinate in that, because it's such a helpful lens, and I'm excited to apply my experiences to it. I really focused on cases involving adult survivors of sexual violence when I did this, and it's because I wanted to come back to my roots and talk about this focus, but a lot of what I do involves crimes against kids, and it is a whole different ballgame because very frequently consent's not an issue, right? Very, very different analysis. So I'm really focusing on cases involving adult victims. So frequently in Pennsylvania, we're looking at rape by forcible compulsion, rape of an unconscious, unaware, or mentally disabled person, rape by causing impairment, sexual assault, indecent assault, okay? These are typically what we're looking at. I highlighted the trickiest of elements that we are trying to overcome. Because again, showing that sex happened, not that difficult usually. Showing the impact on the victim, not that difficult usually. Showing the mental state required, that is the hurdle. So for rape by forcible compulsion, it is by forcible compulsion that would prevent resistance by a person of reasonable resolution. So they need not actually resist, but it's a forcible compulsion that would keep someone from resisting, if that makes sense. And that can include physical, intellectual, moral, emotional, psychological force. So it need not be physical force, and our victim need not physically fight back. But it is still a pretty high burden, right? When you consider that a very natural, expected, understandable, physiological response to being threatened is to freeze, it is a very difficult burden to overcome. Rape of an unconscious, unaware, mentally disabled person. This one is so devastatingly tricky because when you think about sex assault of someone who has been impaired by alcohol, you're thinking someone who is impaired, but understandably, probably someone that remembers something or knew something about what was happening, or maybe outwardly presented as if they knew something was happening, right? Because people often can be completely blacked out but are still functioning-ish. The requirement is that the victim be unconscious, unaware the intercourse was occurring, or suffering from a disability that made them incapable of consent. Well, unaware that it's occurring is quite a difficult thing for a victim to testify about, to know about, to go to a prosecutor to talk about, right? It's a difficult burden. And same with a mental disability that made them incapable of consent. There's not great definitions for that, but it's a high threshold. And then you think about causing impairment, right? The number one drug used for drug-facilitated sexual assault is alcohol. For it to be a crime to impair someone to have sex with them, they need to be unaware that that impairment is happening in Pennsylvania, right? So the person has to be unaware that the substance is being administered to them. for this statute to come into play. It's a big problem when the easiest, cheapest, and most avoidable detection date rape drug, right? I hate that term, but that's what we use colloquially, is alcohol. And the victim's not going to be unaware that they're drinking alcohol. They might be unaware that they're being given a ton of it in order to facilitate a sexual assault, but they're not likely to be unaware that they are drinking. And then sexual assault is our catch-all, right? Sexual intercourse without the victim's consent, and the defendant acted knowingly or at least recklessly regarding the victim's non-consent. So it could be worse, as we've learned. It could be better, it could be worse. And we work with what we've got. The testimony of the victim standing alone, if believed by you, is sufficient proof on which you can find the defendant guilty in this case. The Commonwealth has established all elements of the crime beyond a reasonable doubt. That is the #1 weapon in our arsenal when we go to court. And that is not the law everywhere. But I get to go in front of a jury, and I can say, if you believe this person beyond a reasonable doubt, you can convict on her word alone. And then I always say, but you don't have to just go on that, right? Because there is always more. And I want to talk to you a little bit about that threshold, but first I want to hear your thoughts. So back to Mentimeter, it should still be hopefully up. I'm hoping no one needs the code because they can't see it. Are you okay with this? I want to know, what factors do you think are most important in whether a case will be charged? And you can say just generally for prosecutors, not amazing and like prosecutors like me, right? But you can say across the country, what are prosecutors looking for? What are detectives, police officers looking for? What factors do you think? It's anonymous. I'm not going to know what you're saying. Evidence. Yeah, do you like evidence? I always tease my coworkers that work in like econ and narcotics. I'm like, what's this evidence? Evidence. Give me one victim and like a good prompt complaint. I'm ready to go. I don't want to have to admit things. Relationship with the victim. The offender is age, violence, race, probable cause, witness credibility, and some evidence. Sympathetic victim. Well, what I'll say is this. My analysis is, given what this person has told me, the police, right, because they're not really usually talking to me outside of us making a charging decision. Given what this person is telling us, what evidence would we expect to find? What evidence can we find? And if we can't find it, do we have a good reason why? Can we get a judge, a jury to understand and move past the reason why not? That is the inquiry that is most important to me. So what kinds of evidence may we have, right? The victim's testimony is evidence. I love defense attorneys. There's no evidence, judge, really? I told you all about it. That's evidence, right? We accept it as evidence for every other kind of crime, a theft, or robbery as evidence, but not when it's a woman on the stand or, someone that we can put our beliefs on. Physical evidence, yes, sometimes we do have that. Medical evidence, sure, sometimes. Forensic evidence like DNA, serology. Electronic evidence, communications, text messages. Sometimes we get video surveillance. We're having an increasing amount of video surveillance as evidence. Prompt complaint is what we refer to it generally, but it's when someone discloses to someone what happened very quickly. That's great, but it's also not common. And the disclosure statement, when someone finally does come forward, what is it that makes them come forward and what do they say? And then sometimes we get a defendant statement, right? Some defendants confess. It does happen. It doesn't happen all the time, but it does happen sometimes. What do you think? As you distribute 100 points of importance across these categories, what do you think is most important for us to have prove a case. I have 12 jurors. They have the quality of insight that you would expect from all members of the voting public. They do not get out of jury duty. Okay. Like, yeah. So interesting. This is entirely for me, by the way. I was like, oh, you want a badge? I do the jury class, right? Because there's no answer. I'm not gonna give you the right answer. There's no right answer. And the reason is that every case is completely different and fact dependent. Right? When we are looking at whether, given what the victim is telling us and all the circumstances that surround it, whether we have the evidence we would expect to find, every single case is going to be incredibly different. So, credible victim testimony, yeah. I mean, if I have to put my points in a bucket, that's going to be a really important one. And we're going to talk a little bit about what that means, right? Because we like to say, is the victim credible? And, you know, when you see it, I don't know. DNA forensic evidence. I gotta be honest with you, I have it so infrequently. And it doesn't bother me, because here's the thing. Most of the time, what you are not really trying to prove when you go to trial is whether sex happens. Probably did. You probably did. And if you're getting to the point of trial, even with the delayed disclosure where you don't have DNA or forensic evidence, their defense is probably not going to be that I've never had sex with that person. Their defense is probably going to be that it was consensual, right? So I'm not really worried about DNA. It's nice to have sometimes, but people get like really excited about whether or not it exists. I'm like, may or may not tell us much of anything. Not when it comes down to us making our closing arguments to the jury. Medical evidence or injury. Yes, people do like to see it. I do not expect to see it, so it's not going to make a difference to me when I'm making a decision to charge my case. Vast majority of cases, I'm not expecting medical evidence. What I'm expecting, if they do go to get a forensic exam, which most victims don't, and I don't hold it against them, I'm not expecting any findings. Because most of the time, there won't be. So we come back to our inquiry, right? Based on what I know, based on what the disclosure is, do I expect to find this evidence? I expect to find no injury in most of my cases. If you don't know, vaginas are actually pretty hardy. Things that you didn't think you were going to hear at, 9 in the morning or 10 in the morning on a Friday from the prosecutor. Vaginas are pretty hardy. They actually don't injure all that easily, even in non-consensual sex, right? So I'm not too worried about that. And in fact, most sexual assaults not committed with a whole lot of force. Doesn't make them a whole lot less illegal. So I'm not worried about it. And if any confession, yeah, it'd be great. I never have one, right? But every once in a while, especially the offenders who offend against kids. Here again, another day, right? I also just had a prosecution that finished up where it was a medical professional using deception to sexually assault a whole lot of women, right, under the guise of a medical exam. He actually wasn't even a nurse. He said, "Hi, you're a nurse, it's not your nurse." He gave a pretty solid confession. He didn't say that it was for sexual gratification. He's like, no, yeah, I do that. I check for this and that, and I do these exams. It's like, okay, right? So yeah, sometimes we get those, not too often. A prompt complaint, that is something that like, I am delighted if I see it. But again, I'm not expecting it, right? When you do this work, you have to bring in an understanding of the reality of what victims go through, what trauma does to you. And then your job as a prosecutor is to not get stuck in it, but to educate jurors about why you're meeting your burden. So no, I'm not expecting a prompt complaint. You know what I'd love to see sometimes? Actually, I'll tell you in a minute. I'm gonna make you wait. No motive to lie. Oh, I'm gonna get to that too. I keep getting ahead of myself. No motive to lie. I would say that realistically, when we're looking at cases,
what it's coming down to, right? You have your case, your disclosure, do we have the evidence we would expect to find? And then everything else is this victim credible? Does this victim have a motive to lie? And we're going to talk about what that means too. Those are two of the bigger things to consider. But there's no right answer. This is just fun for me. I like charts. All right, so our challenges that we are overcoming, right? When I talk about delayed disclosure, that is something that is going to create one of the bigger challenges when we're looking at evidence. When we're getting beyond our victim's testimony alone, if believed by you, can be sufficient to convict the defendant beyond a reasonable doubt. We're looking for, well, wait, there's more. And this is the, but wait, there's more. So the challenge of physical evidence in a delayed disclosure case, because most cases are delayed disclosures, it probably won't be there. Right? Number one, you probably won't have physical evidence in a whole lot of cases, but it probably won't be there because if a victim has not come forward until however long afterward, there's a good likelihood that the police will not collect fingerprints, right? They won't collect broken things, I don't know. But then when we think about what we have with physical evidence, again, do we expect to find that anyway? People get so bogged down in what we would like to see so that we have stuff to show the jury, that we forget that what we are actually trying to prove is whether what this person is telling you is true. If someone tells you that they were forced by their husband to have sex during the course of an argument in their home, and that they froze and told them no, but then froze afterwards, are you expecting to find broken things? I'm not. Are you expecting to find, when we look at medical, bruising? Probably not. Actually, I don't expect to find bruising in just about anything. So what you have to think about is, what do you expect to find? So when we don't have physical evidence because of a delayed disclosure, what we do is we leverage it and we find the evidence that matters. We put on victim behavior experts who can educate the jury about why victims fight, flight, freeze, pretty much freeze, right? Why it is difficult for victims to come forward right away, why it is common for them to not be able to say out loud no in the moment, all of these experiences. We combat that and we use it as evidence, right? That is the thing that we are affirmatively putting in. When we have medical evidence that is not there, either because of a delayed disclosure or because the way the sexual assault was committed did not cause physical injury, what we do is we put on what we've got. Right? Maybe the victim took photos. Maybe it is one of those cases where there's some bruising. Doesn't matter if the police take it or the victim takes it. If the photos exist, they exist. And then we also call a medical expert to say, when they did that exam and there were no findings, that's normal. That's normal and it's expected. And that's expert testimony. That is evidence that the jury can consider. When we don't have forensic evidence, we say, well, would it matter anyway? Right? I put up it was a rape of a child case last summer, but I put it up and it was a delayed disclosure. The last time that the sexual assault had happened was about a year before. And we didn't collect any bedding. It was happening in the child's home in her parents' bed. We didn't collect the bedding, but what would a man's semen in his own bed really tell us? Oh, the man who's at one point had sex in that bed. It doesn't matter. It doesn't matter. Right? And with the delayed disclosure, it's not going to show us anything anyway. So it's not being lazy with the facts, not stopping at what the expectations are of people who have watched a couple episodes of Law and Order, and continuing to educate your jury throughout your case, because that's your job and privilege. When we don't have forensic evidence or medical evidence, maybe we do have a victim willing to show us her search history who is searching for Plan B, right? Where can I find Plan B? What do you do if you got raped? Right? People aren't creating search histories in hopes of eventually telling a prosecutor something to get somebody in trouble down the line. They really don't. Maybe they texted someone. Maybe they were absent from work the next day. Right? We look for the corroboration that we can find, and sometimes that's even more powerful. We don't have the physical evidence, but we have a victim that got on the stand and said that while the sexual assault was happening, she was counting the holes on the ceiling tile, and then the officer goes back and takes a picture of the ceiling tile, and damn, those are the right number. Right? Surveillance. We don't have a whole lot of surveillance footage in people's bedrooms where most rapes are happening, right? So when the defense attorney gets up and says, we don't have surveillance footage. Should we? Do you guys have cameras in here? We're not allowed to ask Jordan's question. Do you have cameras in your bed? I mean, well, listen, but do we expect it based on what we've been told? Statements as evidence, because statements, testimony are evidence. A delayed disclosure statement, I don't really care how quickly someone discloses that they've been sexually assaulted. What I do care is about the evidence of how it comes out. That last case I tried, I had the text messages of this little girl telling her friend from the bus what her stepdad was doing to her and how she was really struggling to tell her mom about it. Don't fabricate those. Don't fabricate those. And I care more about that than I care about how quickly she got to the police department. Electronic communications, those are a can of worms, right? We have a challenge here. We have the technology, we have the power to download people's cell phones. Sometimes it's incredibly helpful and incredibly powerful. It's also a huge invasion of privacy, right? And it is a big ask when we ask our victims to give them every thought they've ever had and put into a little box. But we do it, and they do it, and sometimes we get great evidence like communications between a victim and a perpetrator that are really powerful to use. Get those power dynamics. All right, almost there. We do account takeovers and consensual delayed disclosures. We get approval. We call them up. We record the phone call. Okay. And finally, the victim. And I think this is my last slide, so I am wrapping up. Is the victim cooperative? Cooperative is such a horrible word to use for someone who is in the worst possible circumstance in their lives. But we do consider whether this victim wants to go forward with this process. One of the hardest things about my job is that I don't always get to do what the victim wants me to do. I don't always get to charge when she wants me to charge, and that's hard because I actually came into this job because I want to empower people and make them feel better. And I don't always get to decide not to charge because someone doesn't want to go through it. The best we can do is try to balance the needs of our society for protection, the likelihood of a good outcome, and our duty to do everything we can, no matter what decision we're making, to empower and respect the dignity of someone who has come forward against every obstacle to tell us what happened to them. It is the greatest privilege, and I would not trade it for the world. Thanks. This was sorry. One of the last prosecutions I did for a domestic violence attempted rape. She said in her victim impact statement, while the scars serve as a permanent reminder of the trauma, they do not dictate my future. I refuse to let these experiences extinguish my will to live or break my spirit. With unwavering support from my family, close friends, my advocates, I am determined to reclaim my life. I may be a survivor, but I'm also a testament to resilience and the possibility of healing. Have a good job.
Thank you so much to our amazing speakers, fascinating presentations, and we are taking questions.
No audio. Oh no.
Just want to make sure there were no questions on Zoom. If you have questions on Zoom, please put them in the chat. I'm monitoring the chat. Okay, you guys can ask questions. Raise your hand and someone with a microphone will come to you. It can be directed to any panelist. Okay.
This on, there you go, baby. This is for Ms. Marvel. Can you I'm just so interested, what's the process between the victims are obviously coming to like a police officer or the station or whatever. What's the process between they go to the police comes to you? Can you talk about like how you find out about this and those like kind of technical steps?
Yes. when it's a case involving an adult survivor of sexual violence, we have to, and for kid cases, we approve criminal complaints for pretty much all of those charges. Save for like one kind of misdemeanor, we have to be the approving person. And that's part of why I don't have as much data as I would like about the percentage of cases that get charged. So a survivor will come forward, they are making a report to a patrol officer. Maybe it's a detective if they've got a big enough police department. We have like 50 some police departments in Montgomery County, so they're varied in their resources. They're going to give that report. Hopefully they'll be encouraged to seek medical treatment and evidence collection if it's within that window. And then it really depends on the police department. I really encourage those departments to reach out to me early in the investigation so we can work together to find those bits and pieces of corroboration where we can find them. Some cases, they are going to call me right away. It's the middle of the night. We start talking about it and we're going to work through the investigation together. Some cases, they call me when they've conducted their investigation. They are ready to send it to me for a charging decision and they ask what my recommendation is. It's varied, but if a case is getting to the point where they're getting ready to charge, then it has to come to me or to one of the prosecutors I supervise.
Hello. Okay. So my question is also for Ms. Marvel. I'm not a lawyer, so I don't know anything. So excuse my ignorance, but I had a question about when you were talking about unconscious rape. And you said one of the elements is being unaware that sex is occurring. And I was curious if that creates an evidentiary issue with firsthand knowledge. Can the victim still testify if they don't remember it happening?
They can. So it's not an issue of it's just how you put it together, right? So in a case where the victim is unconscious, which more frequently we're proceeding on sexual assault that is not consensual in part because of their intoxication, but let's say they're truly unconscious, what they will testify about is what's happening until they lose consciousness and memory, and then their memory when they pick up from there. And then we will frequently either have physical evidence to corroborate that some kind of sexual interaction occurred or sexual contact. Sometimes we have eyewitnesses that walk in on the middle of it. It just varies, but they're still able to testify. They just obviously are not saying, and then he did this to me, because that would be a conclusion that they may not necessarily be able to make.
This is a question for Professor McJunkin. Referencing back to your discussion about regarding the more masculine, the men are taught to pursue and women are taught to gatekeep. What does the dynamic look like in same-sex relationships, and like what are the implications that come with that dynamic?
You also have microphones on your table, sorry. You guys are
I
good.
guess I get to stay down here. Yeah, so the dynamics differ in same-sex relationships, right? The sociology suggests that men are still taught to pursue, right, even if they grow up with homosexual sexual preferences. But then you might get two pursuers, right? Or you might, so we see these sort of differences play out. But I don't think that changes the dynamic of the analysis at all, right? That is, the story of consent is still a story that like one party has to be the active party who's doing the pursuing, right? And given that the prevalence of heterosexuality in our society is so high, that we're still seeing this as a pattern in which women are primarily viewed as the gatekeepers, right? And so then the power is still viewed, right, in that rhetoric that I think leads to the attacks on consent. The power is still viewed as a power that women hold over men, right? And so we might actually not see, and I haven't seen it, for instance, in the manosphere, right? Much conversation about men being resentful of other men who are gatekeeping. Right? You don't hear that story very often, and I haven't seen any evidence of women creating similar networks like the incel network, or having similar sort of speakers coming out about the need for some kind of enforced monogamy in lesbian relationships, right? So I think the story is very much a story that fits within cross-sex sexual relationships specifically. But I think the socialization part of it is the same growing up regardless, right? I think about this. This is one of the reasons that I think it's important to think about changing our dynamic and getting out of the conversation of consent. I have a 2-year-old son, right? And I'm grappling with like, well, what do I teach him growing up about what's important and what's not important, not just in sexual relationships, but in personal relationships. And what I hate the thought of is teaching him that consent is everything, right? A lot of you get taught that consent is everything, and consent is important, and I want to make sure that people understand that I do think that it's important. But that puts the normative permissibility of your actions in somebody else's hands, right? Like what he's allowed to do is a function of what somebody else decides to let him do. And that doesn't give him very much guidance at all, right? The framework that I'm suggesting for rape law is a framework in which the normative permissibility of conduct is a function of what you choose to do and the power that you have and how you choose to leverage that to cause results, right? And so I would much rather teach him, hey, don't lie to people to get them to have sex with you, right? Don't threaten or compel or coerce or cajole people to get them to have sex with you. Don't sulk your way into sex, right? Don't think about, one of my early articles I wrote about what are called seduction communities, basically pickup artists, right? They have organized strategies, right? Isolate people alone at night, get them confused, take them to an unknown location, right? If they initially resist, make them feel bad about it. All of those things are legal, right? There's absolutely nothing that makes that illegal. It's terrible behavior. And so what I want to highlight for him is like, don't do the bad behavior, right? I don't want to tell him that everything that you're able to do is a function of what other people decide you're allowed to do to them. And so I'd much rather our rape law and our criminal law generally teach people that the normative permissibility of their actions is a function of what they're thinking, what they're doing, and how they're wielding their power in the world. Thank you.
My question is also for you, Professor McJunkin. You mentioned Jordan Peterson, and I'm just curious, with the rise of people like him and Andrew Tate on social media, specifically with the younger male generation, do you think that our social understanding of sex and consent is changing?
Ooh, I mean, it's hard for me to know what's happening, right? I'm terrified by the rise in popularity of people like Andrew Tate, right? And I don't use him in this particular article in part because I'm not well versed in some of the things he said, right? The good news is the enforced monogamy line from Jordan Peterson comes out of like a New York Times article that received a lot of publicity. And so I have a good site, right? If you're on the Law Journal, you know how important it is to have good sources, right? I've never listened to an Andrew Tate podcast or anything, right? But I'm terrified of what it's teaching people, right? In fact, rates of sexlessness are at an all-time high and more often experienced by men than by women. And right, what we're seeing is that that's resulting in a lot of resentment, right? People are taught that somehow sex is an important component of masculinity, that sexual conquest, right, is a function of your value as a human being, and your ability to get sex somehow sort of stratifies you, right? In these within the conversation that they're having, there's alpha men and beta men, and I don't know all the Greek letters, but there's lots of them, right? And I'm horrified, right, that this is the way in which some people are being socialized to think about sex and sexual relationships, right? What I want is I want a society in which we see sex as a partnership. Right? And this is, again, part of my critique of consent, is that I think consent itself teaches us to think about the other person in our sexual interactions as the obstacle on our path to something like masculine status, right? That's a terrible way to think about another human being, is that they're the thing standing in your way from getting what you want, right? And so I want to encourage us to think about ways in which we can change our doctrines to partly change the narratives, right? That is, the more that we teach people that consent is everything, the more we normalize this idea that one party should be the pursuer and the other party should be the pursued. And the more that we normalize the idea that there's some inherent value in getting another person to say yes to you, right? That like somehow that makes you bigger, stronger, manlier. I think that stuff is terrible. And I don't know what to do to disrupt those outside of the scope of my work, which is only in criminal law. But from a social perspective, again, I have a 2-year-old son. I'm terrified of what it's like for him to grow up in this kind of environment, and seeing the spread of those kinds of ideologies is really concerning. Yeah. That probably doesn't directly answer your question, but I'm trying my best. I wish I were a sociologist. In fact, I probably have better answers to the social stuff.
I do have one question on Zoom.
Oh.
So it's for both of you to answer. How do you separate your work life from your home life so that you're not constantly carrying the weight of your work?
You don't. You don't. I'm really interested in and I focus a lot on wellness in this career. And part of it is shifting your mind frame, your frame of mind rather, to why you choose your work. And the fact that it is trauma and you can't put it in a little box and say the trauma stays here at work and at home, I am a non-traumatized person. You can't. You look at everybody as a threat to kids when you're a parent. And it changes everything about you. And then you focus on resilience. You hang up the quote from your victim at their sentencing hearing. You remember why you choose to do the work and that the work is a choice. And that every time you get to have a conversation with someone and leave them feeling a little bit stronger for it, you've done good. And then you go to therapy, and if you don't have enough homemade serotonin, then store-bought is fine, right? But you can't separate them. It's just who you are.
I mean, I'll chime in on this as well, right? So one thing is I don't have the courage of my convictions that Lauren has, right? That is, I went and I practiced criminal law, but I did white collar criminal law. Even though this was sex crimes was an area of extreme interest for me, I knew that if I had somebody's, somebody's story in my hands, and I had to try my best to make an argument that respected them, that I would be obsessive about it, that I wouldn't be able to sleep at night if I had done a bad job. And so I opted out of some of that, right? And I get to approach this from a very academic angle. But still, right, the thing that that motivates me is that I have the privilege of being able to be in a position where I can try to do good in the world. And that's really important, right? Like, I think everybody is going to be much more energized and motivated to do a job if you see actual meaning in the work that you're doing, right? If for those of you who are aspiring young lawyers in the room, right? Yeah, you can go get a job doing commercial litigation and writing angry demand letters to your opponent, and it'll probably pay you quite well, but it's not going to be like morally fulfilling, and you'll get burnt out on it, right? The stuff that's going to motivate you to continue doing the job for decades is the stuff that you wake up and you think about, the stuff that you think, I can actually make a difference and make the world a better place. And so I don't think it's about separating in any kind of sense. I really do think that it's about embracing your capacity to make a change that you want to see in the world.
I think we have time for one more question. I know Tamara had a hand up. If you want to.
Oh, well, actually, he's got a microphone.
Oh, okay, Josh. And maybe we can take two because I know Tamara had her hand up. So we'll take two. Josh.
Mine is for Professor McJunkin. Earlier in your speech, you referenced the concept of freedom of choice for individuals and how there was negative stereotypes being created off of that concept. But at the ending of your speech, you said you wouldn't want the world to be based around consent or individuals giving consent to other people, and that shouldn't be determining our actions, or you wouldn't want your son to be living his life like that. But I view not the counterpoint, but the opposite view of that is freedom of choice. So if we have freedom of choice creating this negative stereotype, what would your proposed alternative be to not have this negative stereotype, but enable for people's rights to be viewed in this fashion?
Yeah, so I mean, I think the key here is that I don't think in terms of rights, or at least I don't think that it's a good thing for us to frame rape law around, right? To the extent we do, we could think about something like a right to human dignity. I don't like that language, right? My approach to criminal law specifically has always been an approach that comes from the place of culpable wrongdoing is something that the criminal law has an appropriate place to sanction. And so when I think about consent, right, one way to think about it is the way that legal philosophers often do, which is we have a right to sexual autonomy, that is a freedom of choice. And that when we consent, that right is not violated. If we don't consent, the right is violated, and we should only punish when there's non-consent, because that's the violation of the one right that matters. And what I try to say in my presentation, what I hopefully have expressed with respect to my son, is that the idea, I think there's more wrongdoing than just the violation of that right. And that I think a lot of that wrongdoing is culpable. People are intentionally deploying mechanisms to try to get sex from other people in ways that are destructive to humanity. And I think that there's space for the criminal law to sanction that wrongdoing simply by structuring our rape law differently. And that I think the hope is that in doing so, we can start to teach the people who would be offenders to take more accountability for their own actions, to think more closely about the choices that they're making, Now I think we can pair that, right? I didn't get to this part of my slide, but I think we can pair that with like alternatives to incarceration, other ways of dealing with mass incarceration, right? Just because I want to label something as rape doesn't mean that it deserves the harshest possible sentence, right? And we can have gradations. The model penal code does this. It divides rape into 7 distinct crimes, 7 different versions of sexual assault. And there's lots of avenues that we can go down criminally. But what I'm trying to do is I'm trying to open our minds to the idea that there is more wrongful about sexual intercourse than just non-consent. And then in fact, the narrative of non-consent, I think, closes off some recognition of the various ways in which people are mistreating each other. And so that's the emphasis. I just want to refocus the way in which rape law approaches that question.
Question.
Hi, my name is Tamara Wilson, and my question is for Ms. Marvel. We talked about the factors, and you discussed that the fact that the sex occurred is not usually like the challenge element at trial is usually consent and closing arguments. So my question would be, is it more difficult to trial a case where the victim had a previous relationship with the defendant, maybe over a span of several years, where she gave consent in the past, but in this instance, she did not give consent?
It can be, for sure, right? Mostly because we are fighting, and that's the thing that I didn't get I didn't manage my time well on, right? We're fighting rape myths and stereotypes and sexist beliefs about consent that are living in our jurors, judges, police officers, everybody, including our perpetrators and our victims. So when you have a prior history of someone having given consent, yeah, it's absolutely a challenge. But also, what I like to turn that to is, all right, well then why lie about it being non-consensual on this occasion, right? Why, I mean, when my friend was sexually assaulted, part of the sexual encounter was consensual, part of it was not. And she was very clear that she was like hoping to hook up with this guy, right? When she's clear that she's hoping to hook up with this guy and then something that she is not consenting to happens, why in the world is she running to her friend with tears streaming down her eyes saying she was just sexually assaulted, if not because it's true? So what you have to turn to is, what is the focus on, right? It's the interaction. You're zooming in on what was happening in that relation just prior to this event, what happened to it just afterwards, and what do we have to corroborate the experience that the survivor had. And when it comes to the motive to fabricate, I tell my prosecutors, there is always going to be a motive to fabricate, because we live in a society that will do anything to not believe women, and not just women, right? Also male sexual violence survivors. But all we want to do is believe that women will lie, that they will manipulate, that they will use the system to their advantage. So we are always going to deal with a motive to fabricate, and that's what's going to come up in those prior sexual relationship cases. But we have to embrace that not every case is going to be a slam dunk, but it doesn't mean it's not worth trying, right? And we have to focus the attention on, what did this perpetrator do? And is that motive to fabricate born out of something legitimate, or is it born out of sexist beliefs?
Thank you, everyone. Thank you to our panelists. We will now take a short break, and we will reconvene for the start of the next panel at 10:45. Thank you. That real quick. Okay, it's just CLE. Perfect. Okay. Okay, everyone. We're going to start our second panel, domestic violence, and I'm going to introduce our panel moderator, Dean Randi Teplitz. Randi Teplitz has been an advocate for women and other vulnerable members of our community for her entire adult life. She is currently the Assistant Dean of Students and an Adjunct Professor of Law at the Widener University Commonwealth Law School in Harrisburg, PA. A lawyer by training, Dean Teplitz began her career by representing victims of domestic violence in protection from abuse, custody, divorce, and economic support cases. She served as a staff attorney at Central Pennsylvania Legal Services, now Mid-Penn Legal Services, and then as the founding director of the YWCA of Greater Harrisburg's Domestic Violence Legal Center. My apologies. While Dean Teplitz was proud of her work as a lawyer, she sought to expand her impact by training the next generation of public interest lawyers, which led her to move full-time into academia. Dean Teplitz was appointed as the chair of the Pennsylvania Commission for Women by Governor Tom Wolf in 2015 and remained in this position throughout his administration. In this role, she served as the leader of a 34-member statewide commission that provides advocacy on public policy issues affecting women and girls. She also played an instrumental role in programs that included eliminating sexual violence on college campuses, honoring female veterans and glass ceiling breakers, advancing wage equality, supporting women's healthcare, and empowering young women through leadership and STEM initiatives. Dean Teplitz is a graduate of Temple University and the Widener University School of Law. She was named one of the 50 top lawyers in Pennsylvania on the fast track by the Pennsylvania Law Weekly and the Legal Intelligencer, and received a Women of Distinction Award from the Seroptimus Club International and the Women of Influence Award from the Central Penn Business Journal. Please please join me in welcoming Dean Teplitz. My apologies.
Thank you. Thank you, Jessica. Thank you, Law Review, for this wonderful program today. And it's certainly dear to my heart and brings me back to my roots. And I'm happy to see my former colleague, Rachel Pinsker, on this panel. She and I worked together for many years doing this work. Our first presenter today, I think most of us know and love, one of our very own here at Widener. Professor Buchhandler-Raphael is a tenured associate professor of law at Widener University Commonwealth Law School. She studies the intersection of criminal law, criminal procedure, and family law. Her scholarship focuses on gender-based violence, including sexual violence, intimate partner violence, and domestic violence. Her work explores ways to reform the legal system's treatment of victimized offenders, that is, individuals who have endured abuse in domestic settings and subsequently become involved in the criminal legal system as defendants. She also examines alternatives to policing domestic violence by dispatching non-police responders to provide emergency services in certain non-physically violent domestic incidents where there's no indication that the abuser is armed. Professor Buchhandler-Raphael is a prolific scholar. Her articles have been published or are forthcoming in prestigious law reviews, including the UC Davis Law Review, Washington University Law Review, Fordham Law Review, Arizona State Law Journal, Cardozo Law Review twice, Florida State Law Review, American University Law Review, Temple Law Review, Tennessee Law Review. As you can see, she likes to write and publish and is very well recognized in that space. The Richmond University Law Review, and the Family Law Quarterly, among others. We are so privileged to have Professor Buchhandler-Raphael on our faculty and here today. Thank you.
So thank you so much, Dean Teplitz, for this super kind introduction. The paper that I present today is titled Compassionate Undercharging, and it examines the question, how should the criminal justice system treat victimized offenders? Why is it moving? Something happened to this. Brian, can you help me? Okay, oops, yeah, okay. So I use the term victimized offenders to describe individuals who have experienced domestic abuse and kill either their abusers or third parties as a result of that abuse. And this definition clarifies the scope of this project. Victimized offenders is a broad catch-all term that can describe abuse defendants in various circumstances because victimization can extend beyond domestic settings. However, in this project, I focus on abuses in domestic settings to highlight the prevalence of the connection between victimization in the family and crime perpetration. In addition, victimized offenders in domestic settings commit various crimes, not just homicides. But in this project, I focus exclusively on those charged with murder due to the uniquely harsh consequences of murder convictions, which typically include a life sentence, often as a mandatory minimum. And my main thesis is that prosecutors should recognize the correlation between victimhood and offending and refrain from bringing murder charges against victimized offenders and instead pursue lesser charges. I describe this practice as undercharging and offer 3 rationales to justify it. 1, undercharging aligns with the purposes of punishment. 2, prosecutors' key role is to do justice. And 3, prosecutors' legal and ethical obligations towards crime victims. I would like to situate this project within the framework of my prior work and a broader research agenda. So I'm a family law and criminal law scholar who studies domestic violence and particularly the correlation between homicide law and gender-based violence. This project is the 4th installment in a series of papers I've written on this correlation. In previous work, I have explored legal doctrines that could alleviate the criminal justice system's harsh treatment of victimized offenders. Specifically, I have considered legislative solutions, including expanding the scope of existing defenses such as provocation and self-defense. Additionally, I have proposed that state legislatures adopt a specialized homicide offense designated for victimized offenders to reduce their criminal responsibility. And an overarching theme in my work, including this piece, is whether mitigation should be reserved for sentencing. Conventional wisdom in criminal scholarship holds that mitigation should be considered during the sentencing phase of the trial rather than the guilt determination stage. In contrast, my papers advocate for reforms that mitigate criminal responsibility itself rather than merely reducing sentences of victimized offenders. And in this project, I focus specifically on prosecutors as potential agents of leniency, a choice that I will explain later. So let me give you the roadmap for the next 15 minutes or so. So I'll begin with presenting a typology of victimized offenders. Next, I will describe the shortcomings of existing frameworks in victimized offenders' criminal trials. I'll then examine current prosecutorial undercharging practices across various contexts and consider the potential for expanding undercharging. And finally, I will present the theoretical justifications for the compassionate undercharging proposal. Now, the victim-offender overlap is well documented in social science literature, with ample studies describing the correlation between victimhood and offending. But the legal implications of this overlap largely remain understudied. Criminal law and the prosecutors who enforce it adopt this perceived dichotomy between victimhood and offending. However, social science research reveals that this dichotomy is false, as individuals are frequently both offenders and victims of crime. Existing legal scholarship primarily focuses only on one type of victimized offenders, the battered woman who killed her abusive partner. As a result, the literature primarily critiques the elements of self-defense and proposes expanding its scope to account for the typical experiences of battered women. However, this category of victimized offenders represents only the tip of the iceberg in a much broader phenomenon, revealing a substantial correlation between domestic abuse and crime perpetration. So the paper draws primarily on 2 types of sources to identify additional categories of victimized offenders. First, New York court decisions applying a statute that the New York State Legislature adopted in 2019 titled Domestic Violence Survivors Justice Act, which authorizes courts to re-sentence victims of domestic violence whose victimization contributed to their commission of various crimes if the court finds that their original sentence was unduly harsh. Second, a recent empirical study examined the pathways that led to the incarceration of women in 2 correctional facilities in California for murder and manslaughter. A quick word about this study's methodology. 649 women completed an anonymous survey on the context of their crimes and a risk assessment questionnaire measuring the presence and severity of intimate partner violence in the year prior to their offense. And the study's key findings reveal that 74% of those in relationship, that is 464 out of 625 women, screened positive for intimate partner violence. And of those, 66%, that is 308 women, were at extreme risk of being killed by their partners. And in the paper, I focus on the 5 common categories of victimized offenders. The paradigm example is the woman who killed her abusive partner. But the sources I just mentioned earlier identify 4 additional categories of victimized offenders. First, individuals who kill third parties under threats or coercive pressures from abusive partners. So for example, women forced by their abusive partners to drive a getaway car during a robbery or be the lookout in a drug deal, they become accomplices to murder if their partner's felonies result in killing the victims. Second, mothers charged with the death of their own children that resulted from abuse by their partners. They are charged either based on accomplice liability or omission liability under failure to protect laws. Third, individuals who kill abusive parents or other family members or foster parents. And finally, sex trafficking survivors, because traffickers are often family members or intimate partners. And even when they're not, the abuse endured in domestic settings often lead into commercial sexual exploitation. So I'll move to describe the problems that victimized offenders face in their homicide trials. First, the default prosecutorial practice is to overcharge, that is, routinely bring murder charges, often to leverage guilty pleas. Second, existing defenses such as provocation, self-defense, and duress often prove unfit to reduce victimized offenders' criminal responsibility. When victimized offenders kill their abusive partners, they typically raise self-defense claims, right? However, the prosecution is often able to disprove the imminent threat to kill element. Also, self-defense claims are not available to those who kill third parties. They could potentially claim that they acted under duress, but this claim is typically rejected because duress is interpreted really narrowly to exclude coercive pressures that are more tacit and implicit. So when no defensive claims are available, past abuse may serve as a sentencing mitigation factor during initial sentencing and resentencing. But these frameworks only mitigate the sentence rather than reducing the degree of criminal responsibility itself. In short, the criminal justice system's treatment of victimized offenders is unfairly harsh, failing to account for the impact of domestic victimization on their decision to commit homicide. And this leads me to consider potential reforms. There are 3 types of institutional actors who could advance reform in this area. First, state legislatures. They could expand the scope of existing defenses or adopt a specialized offense to prosecute victimized offenders. Second, the judiciary. Sentencing judges can expand their recognition of domestic victimization as a basis for sentencing mitigation. And prosecutors. Prosecutors could adopt practices under which they would pursue lesser charges against victimized offenders. And in this project, I focus on this third option of prosecutors as agents of leniency. Before laying out the justifications for my proposal, I would like to situate undercharging within the broader framework of existing prosecutorial practices. Undercharging is a common prosecutorial practice in various other contexts where prosecutors routinely pursue lesser charges than those authorized by law. Undercharging is a subset of what is known as declination decisions. Declinations encompass three practices: the prosecutor's initial refusal to charge, the dismissal of an earlier filed charge, and undercharging, where prosecutors file lesser charges. Now, some may mistakenly believe that only so-called progressive prosecutors undercharge. But in practice, all prosecutors, including conventional tough-on-crime prosecutors, they routinely undercharge by reducing homicide charges from murder to manslaughter, but they do it through plea agreements. They do it for strategic reasons, such as efficiency and resource conservation. In contrast, my proposal for compassionate undercharging is innovative because it is driven by leniency, and specifically by the exercise of mercy toward victimized offenders because they are also victims. So the novelty here lies in challenging this conventional dichotomy in criminal law that separates offenders from victims by recognizing that a person can simultaneously occupy both roles. So this raises the question, what are the justifications for such charge reduction? And in particular, why should prosecutors engage in this practice? And I'd like to elaborate on three main justifications, the ones I mentioned in the beginning. So the first rationale for undercharging victimized offenders is that it aligns with the justifications for punishment, including the retributivist principles of just desert and proportionality. These principles demand that individuals should not be punished more harshly than they deserve. Victimized offenders' moral culpability is diminished because what triggered their crime was a survival motive. Compassionate undercharging can be described simply as proportionate charging that reflects the offender's reduced moral culpability. The second justification is grounded in prosecutors' role in doing justice and exercising proportionality in charging decisions. Charging decisions are largely discretionary without any meaningful judicial oversight. There's only one United States Supreme Court decision, Berger, that instructs prosecutors to do justice. But this guidance is vague and not really helpful, as different prosecutors have varying interpretation of what qualifies as doing justice. For some, it means bringing the highest charges authorized by law. In contrast, the prosecutorial model that I envision here suggests that doing justice means undercharging victimized offenders because this practice aligns with the principle of proportionality in charging decisions. So legislatures, they make broad distinctions regarding moral culpability. For example, intentional killing is considered more culpable than negligent killing. But in most cases, legislatures leave the finer line drawing to prosecutors through charging decisions in plea bargaining. So the relevance of victimization to moral culpability may seem intuitively obvious to many of you. I posit that failing to consider it departs from proportional charging and urge prosecutors to make a fair, informed assessment of an offender's blameworthiness by adopting undercharging practices. Prosecutors have limited tools for assessing blameworthiness. They are definitely not philosophers. They would benefit from reasoned analyses of recurring situations, which is the goal of this project, right? To offer guidelines to structure prosecutorial discretion. While victimization is certainly not a substantive defense, it does serve as a mitigating factor in assessing blameworthiness. Although it does not legally justify or excuse homicide, I believe it can render it a more understandable response to domestic victimization. And the third justification is grounded in prosecutors' legal and ethical obligations towards victimized offenders. This rationale frames abuse defendants as victims of crime themselves. The legal duty to ensure fair treatment of victims can be derived from state constitutions, most of which require prosecutors to treat victims fairly and with dignity and respect. Since victimized offenders are also victims, I believe that prosecutors have a corresponding duty to treat them fairly and with dignity. Beyond legal duties, ethical guidelines also support undercharging victimized offenders. The ABA standard for the prosecution function mandate that in their charging decision, the prosecutor should consider the background and characteristics of the offender and whether the authorized punishment is disproportionate in relation to the particular offender. So it is plausible to interpret this guideline as instructing prosecutors to consider a defendant's history of domestic victimization when making charging decision. I will end with the doctrinal implications of my proposal by outlining the three elements of this proposed standard or guideline. So the first, the defendant must have been subjected to physical or sexual abuse or been a victim of sex trafficking at the time they committed the crime. Two, the abuse or trafficking must have occurred within a domestic relationship or in the context of commercial sexual exploitation. And probably most importantly, the abuse must have significantly contributed to the defendant's participation in the crime. So just to conclude, prosecutorial undercharging is just one strategy in alleviating the criminal justice system's harsh treatment of victimized offenders. It is certainly not mutually exclusive with other types of reforms. Comprehensive reforms require the collaboration of prosecutors, sentencing judges, and legislatures. Thank you very much.
Thank you, Professor Buchhandler-Raphael. Worried that I'm going to miss. There we go. Our next presenter is Natalie Nanasi. Natalie is an associate professor at SMU Dedman School of Law. She is also the founding director of the law school's Judge Elmo B. Hunter Legal Center for Victims of Crimes Against Women, where she teaches and supervises students representing survivors of gender-based violence in a broad range of legal matters, including humanitarian, immigration, family, civil, and criminal law, and oversees students' systemic advocacy efforts that aim to both prevent and seek long-term solutions to the problem of violence against women. Professor Nanasi's research explores the intersection of gender and feminist theory with the Second Amendment and immigration law. Her scholarship has appeared in numerous journals and law reviews, including the Wake Forest Law Review, Harvard Law and Policy Review, Ohio State Law Review, Yale Journal of Law and Feminism, Temple Law Review, Villanova Law Review, and Columbia Journal of Gender and Law. Please help me welcome Professor Nanasi.
Good afternoon, everybody. Let me just pop this in the right mode. Okay. Thank you, everybody, for having me. This has been such a great morning so far. I've got a high bar, but hopefully I can reach it. All right. So I am here to talk about, as you heard, my research focuses on the intersection of intimate partner violence and the Second Amendment. I assume if you are in this room, you were following last term in the Supreme Court when the court upheld the constitutionality of the federal law that disarms those subject to domestic violence protective orders. So as advocates, we all breathed a sigh of relief. Okay, this law that is going to take guns away from people who cannot be trusted to use them responsibly has been upheld, right? So that's settled. I put in air quotes, way outside the scope of what I'm here to talk about, but it's complicated, this constitutional issue, which again is great news. The problem is that what that leaves us with is the status quo, which is some great laws on the books that are not being enforced basically anywhere, right? So the focus of my talk today is on how we can enforce these laws that have been and will now continue to be on the books. All right, so what I want to do, of course, is to back up a tiny bit and situate us in the problem. So as you might expect, domestic violence and firearms are a deadly combination. Between 2003 and 2014, over half of female murder victims under the age of 45 were killed by an intimate partner. Firearms are used in the vast majority of intimate partner violence deaths. They are greater than all of the other means combined, okay? Don't want to belabor that point. The second point is that the prohibitions that are on the books are effective. So specifically on the protective orders, studies have shown anywhere between an 8 and 25% reduction in intimate partner homicide in states that have laws that prohibit those who are subject to domestic violence protective orders from possessing firearms. But again, as I said, these laws are rarely enforced. I mean, you really have to find sort of lightning in a bottle in a jurisdiction where you see these laws being enforced. That is also complicated outside the scope of what I'm here to talk about today, but very briefly. There's a really challenging interplay in this space between federal and state laws. They sometimes complement, they sometimes diverge. Think about who's going to show up to physically do that. Is it the ATF? Is it the sheriff, right? Super complicated. There's an absence of coordination in and communication in locality. So think about, you've got an arresting officer, a detective, a prosecutor, judges, probation departments. All those need to be working together to make this work. And a lot of times you don't see that coordination. There are a lack of programs and protocols across the country to facilitate enforcement or surrender, right? Like, what are they going to do with it? Where are they going to turn it in, right? There's a lot of logistics involved. In order to make that happen, you need money. You don't see a lot of money in this space, which also says to me, there's not a lot of political will, which you would think would be surprising, but it is not. And then finally, sort of overlaying all of this is just Second Amendment stuff and in general, but mostly there's a lack of a comprehensive national system for gun registration. So if somebody denies possession, we're really unable to verify the veracity of that statement. So all of that said, what we are left with is an honor system, right? We say to perpetrators when we get them a protective order, when they're convicted, you are not allowed to possess firearms. And usually that is where that ends. So we have to entrust these folks to comply voluntarily with the law. And as you might expect, that is often not happening. But what I really wanted, I've been writing about this for a long time. And what I really started to think about is, look, actually, let me not get there quite yet. So how are we going to enforce compliance here, right? Like, I've been in rooms with prosecutors, like, we will find you, we will arrest you, right? Like, how are we going to do this? And what I realized kind of being in this work for a long time is that nobody is actually asking these guys, the people who are arguably most impacted by these laws, what their perspectives are, right? And I think that's really important, because imagine a scenario where they're saying, wait, what? I'm not allowed to have a gun, right? So that's a reason, right? Or maybe they're saying, look, if I give this up, I'm going to lose my job, right? And we know that unemployment is a huge risk factor. Maybe we'll hear about that momentarily for intimate partner violence. Are they intending to use that firearm to commit further intimate partner violence? Or, as we know, there's a correlation between that and mass shootings or violence in the community, right? Is the neighborhood where they live unsafe? So, which leads them to conclude that they would rather be caught with the gun than without it, right? These are all really different reasons for non-compliance. And I think it's incredibly important for us to understand what the underlying reasons are if we're trying to think about policy solutions as we're living in the world that we are living in, right? So what I hope to do with this article is really to answer these two potentially simple questions, right? The first is, why don't perpetrators of intimate partner violence relinquish their firearms when they're ordered to do so? And is there anything we can do to incentivize that compliance, right, so the way that I did this, and I'll go through this pretty quickly, is my students and I actually went into our local batterer intervention program, and we talked to these guys, right? These were all people who had been ordered to participate in this program after being charged with a family violence offense against an intimate partner, right? We, you know, in the parlance, sociology, again, gosh, everybody needs to get a dual degree in law and sociology, and social science. So it's a mixed methods, which means we both had them fill out a survey and we talked to them, right? We sat down with them, we talked to them. Some interviews were real quick. Some of them lasted a really, really, really long time. And so what I'd like to share with you is what we found. All right, so really quickly, these are the demographics. You see a pretty broad age range, a decent racial spread, 25 discrete zip codes across our sprawling metroplex. So these are men really living across, I should mention I'm from Dallas, so we did this in DFW, Dallas, Fort Worth. And the underlying charges here are primarily felonies, as you see. So these are sort of, this is kind of who we were talking with. Incidentally, I was saying at dinner last night, it's fascinating. You heard I run a gender violence clinic. So for the students in here, it was like, hey, you're here to represent survivors. It's like, actually, guess what? This semester, we're going to be like talking to offenders. And I think it's like a really great exercise to think through. Like, as we, you know, seems like the theme of this is like context really matters, right? Just, it's like not everything is black and white. And hopefully we get that across. Okay, but I digress. All right, so let me tell you what we found. And these are the 5 things. I'm going to go through each of these one by one, and I'm not going to read them because you can, and everybody's been running out of time, and I'm going to maybe try not to do that myself. All right. So knowledge of prohibitions. Gosh, wouldn't it be easy if the first thing I said were the case, right? If people were like, oh, shoot, I had no idea, right? So sadly, that is not the case. We asked them, do you know that you're a prohibited possessor because of your conviction? And you will see here that 75% of them were like, yeah, I know that, right? So not an easy fix. It's not as simple as the judge or the prosecutor or even the defense attorney saying to them, hey, listen, FYI, you're not supposed to have this gun. Federal law, state law, about half the states have state laws prohibiting this, right? So sadly, we do not have an easy solution to this problem. Although certainly let's not dispense with that. Let's just make sure we are still telling them, right? And I think the defense bar is actually really, really critical in this. They tend to be a more trusted messenger oftentimes, and the penalties are very, very steep, right? So in terms of jail time and in terms of finance. So it's definitely worth telling folks, hey, by the way, you're not allowed to have this gun. Okay. So the next thing that we found was significant past victimization in this community. So let me walk you through this. If you're like me, I don't understand charts until somebody walks through them with me. So we asked them about the prevalence of crime and gun violence in the neighborhoods where they grew up, right? So we found that 64% of these men said crime was either a moderate or a big problem in the communities that they grew up. And that's that first bar graph. The second one is gun violence, right? So how big of a problem was gun violence in your neighborhood? And you're seeing those first two darker bars there. You see that it's either a big problem or a moderate problem where they are growing up. So this is sort of back when they were kids. And younger adults. We then asked them about victimization experiences, and this was really the most significant finding. So okay, so we asked this range of questions trying to capture a lot of different things. This first, have you been a victim of crime? Have you witnessed a violent crime? Has someone you know been a victim of violent crime? Have you been shot at, or has someone you know been shot at? So we found that 44% of these men had been a victim of a violent crime at some point in their lives. To situate that, the Bureau of Justice Statistics estimates that in the United States, gosh, I wish I had that cool, but any guesses nationwide what the number is? Shout it out. These guys are 44. We think it's higher or lower. We'll do prices right. So, right. 20 lower. Yeah, it's actually 2%. 2% of people in the United States have been a victim of violent crime, and these guys are at 44%. So that to me was absolutely astonishing. 77% had witnessed a violent crime. 81% knew someone who'd been a victim of violent crime. And then when we drill down on the gun question, 54% of them had been shot or shot at. Of those, 87% were intentional. And 77%, these statistics are just absolutely shocking. 77% knew someone who had been shot or shot at, and of those, 95% were intentional shootings. Okay. I mean, these numbers are staggering when you think about them compared to what sort of the average American. I mentioned we got numbers. That's the quantitative part. This is the qualitative part, right? We asked them to describe. I'm not going to read this to you because you can read. But again, some of what we heard was really eye-opening. And you start to feel just what their lives are like, right? Hopefully experiences that many of us are not having to experience in our lifetimes. And again, this is consistent with research that shows that victimization experiences are very correlated with gun ownership, right? And in some ways that's intuitive. You think about, oh, something scary happened to me. And there's a lot of messaging out there is like the way to keep yourself safe is to arm yourself, which by the way, is not actually empirically true. But we know that having a gun in the home, regardless of who it belongs to, is going to increase, especially in situations of intimate partner violence, the likelihood of death. Right. So even if somebody is getting a gun ostensibly to protect themselves, oftentimes it will end up, it's more likely to be used against them. But again, that's just kind of what we see happening is that victimization experiences are very, very highly correlated to gun ownership. Okay. We then asked them about current feelings of safety, right? We talked to them, okay, tell us what happened to you before, like what's it going on now? Now, again, many people, it was less. Thankfully, many of these guys had found some more safety, but we definitely heard a lot about them still not feeling safe where they are, right? So you can always hear gunshots, bullets flying through the house. I'm hearing gunshots. I'm just always looking over my shoulder, right? To make sure that, that I'm going to be safe. And then relatedly, sort of the last data point on this is trust in law enforcement, right? And as you might expect, it was pretty low. So we asked them, oh, sorry, I don't have a slide on this. So we asked them sort of just a lot of questions around what are your feelings? Can you trust that law enforcement is going to be there, right? Kind of with this assumption that they're not feeling very safe. And we just heard across the board, participants found that police are ineffective, that response times were inadequate, which is a marker of under-policing in historically marginalized communities, fears about bias, which is a marker of over-policing, and that bias relating both to race and to prior criminal history, right? And sort of this big picture idea, like if you don't want to go to jail, don't call the police, right? They're going to take one look at me, they're going to ask about my priors. And if I call, even if I'm at risk, if they come, it's going to be too late. And when they come, I'm going to be the one that gets in trouble. So there's just like not a lot of faith in law enforcement to keep people safe. So taking all of this together, protection was the most significantly cited reason for gun ownership among these guys, right? So, and again, we asked them in kind of a lot of different ways to get at this. So you might not be surprised to hear that we did not get a lot of admissions from guys who knew that they weren't supposed to have guns, that they had guns. I think like no, not one person admitted to us that they still had a gun. So we tried to ask like, well, if you ever had one, why'd you get one? And why would you hypothetically want one? And why do you think somebody else might want one? And like, if you had one hypothetically, like, why would you be reluctant to surrender? And why do you think other people might be reluctant? So we got the highest answers, that big bar that you see in the middle there. And then the one on the right-hand side, those are answers to the hypothetical questions that, again, I think they probably felt a little bit safer answering, right? But you see that these answers around protection of others, like I need it to keep my family safe, my grandma, my kids. That's that first part. The second one is keep myself safe, and then protecting property and protecting against crime. Those were a little bit lower, but really protection is above and beyond the highest reason that people either actually or hypothetically said that they would be reluctant to comply with the law. All right, so some other findings that, and these are I really don't want to go through this quickly, right? Just sort of, I feel safer. I just, I know people who have been hurt, and this it was fascinating because my guy said this, and you see this in the literature across the country. I'd rather get caught with one than without one, right? Super, super important. Okay. Other findings really quickly, there's a lot of stuff in the paper about hegemonic masculinity, sort of like what guns mean about masculinity. These guys have a lot of thoughts about the Second Amendment. They're mostly wrong. And a lot about, I'm from Texas, right? You might imagine that sort of community norms around gun ownership. Everybody's got one. I need it for hunting, for sport, all that stuff. That's all in the paper. I do not have time. But I just really, really want to quickly end with talking about some solutions, right? So carceral approaches, of course, have limits, but I do think that the legal consequences are a necessary piece of this puzzle, right? We cannot dispense with those either. I mean, we did hear, I don't want to catch any more charges, right? About 32% of the participants indicated that criminal consequences had or would lead them to surrendering firearms, right? So I don't think we can dispense with the legal piece. But we're doing that, right? Could we do it better? Yes. But the other piece of this that we're not doing anything about, or at least we're not making the connection, is making our communities safer and more prosperous, right? So what that looks like, and when we have evidence that crime is disproportionately concentrated in economically distressed areas, and that reducing poverty reduces crime, right? So access to healthcare and housing, investment in infrastructure, and neighborhood investment projects, all those things. So if people feel safer, they are less likely to feel like they need those guns. They are hopefully more likely to surrender them. So again, happy to answer questions later, but really, I think these offender perspectives are really important because the insights of those who are impacted by these regulations can help us, as I said at the beginning, promulgate laws and policies that are more likely to lead to compliance, especially because enforcement is otherwise, unfortunately, really lacking. Okay, and I will end there. Thank you.
Thank you. That was really fascinating because when I used to negotiate protection orders, most of them get resolved by agreement. And so the defendant would agree to not abuse, be evicted from his home, grant custody to, pardon the pronoun, grant custody to the victim. But then when you would get to the point about relinquishing weapons, that was the sticking point that would take us to a hearing so often. So it's fascinating to contextualize it from the lens that you just did. So thank you for that. I hope I didn't step on your presentation at all. Our next presenter is Rachel Haynes Pinsker. Rachel has devoted her legal career to assisting victims of domestic violence and sexual assault. Rachel is the managing attorney for the Domestic Violence Legal Center located in Lancaster County, Pennsylvania. DVLC provides holistic legal assistance to victims of domestic violence in civil legal matters. Prior to joining DVLC, Rachel served as the legal services manager for the Pennsylvania Coalition Against Domestic Violence, a private nonprofit organization working at the state and national levels to eliminate domestic violence. She has also practiced extensively in the counties of Philadelphia, Dauphin, Adams, and York on behalf of victims of domestic violence. Rachel is also an adjunct professor at Widener University Commonwealth Law School, where she teaches family law and legal methods. Rachel began her career as a law clerk for the Honorable Leslie Gorby, Court of Common Pleas, Lancaster County. She holds a Juris Doctor from the City University of New York School of Law and a Bachelor's of Arts degree from Millersville University. Rachel, thank you.
Get this set up. There we go. So I'm going to talk to you all about screening for domestic violence, what lawyers need to know from a practitioner perspective, because I'm a practitioner. And all of you, when you pass the bar and are practicing attorneys, if you are representing individual clients, particularly if you're practicing family law, you're going to have clients that are experiencing domestic violence and or perpetrating domestic violence. And so it really benefits you to have a good understanding of what domestic violence is. And again, particularly if you're practicing family law, 23% of all family law cases involve domestic violence, 50% of divorce cases involve DV allegations, and 2/3 to 3/4 of custody litigation involves domestic violence. So you're going to come across it. Myth versus fact. Domestic violence affects only a small percentage of the population and it's rare. Shout it out. Myth? Okay. It's a myth. I always say if this were true, then I would have been out of a job a really long time ago. National studies estimate that 3 to 4 million women are assaulted each year in our country. And one study found that 31% of women surveyed admitted to having been physically assaulted by a husband or a boyfriend. So 10 million women and men are physically abused by an intimate partner every year. That number is probably low, right? Because we know that crimes of domestic violence and sexual assault are largely underreported. We do know that, again, 1 in 3 women and 1 in 4 men have experienced some form of physical violence by an intimate partner in their lifetime. 1 in 5 women and 1 in 7 men have experienced severe physical violence. Research also tells us that although most victims of domestic violence are women, domestic violence occurs regardless of gender, age, race, ethnicity, mental or physical ability, socioeconomic status, sexual orientation and identity, religious beliefs, or background. Domestic violence impacts everyone. And it's not something that individuals can insulate themselves from. So the Pennsylvania Coalition Against Domestic Violence tracks domestic violence homicides in Pennsylvania. In Pennsylvania, homicides are not categorized by type. So even though every single crime is reported, there's no way to know which of those homicides were actually domestic violence homicides in Pennsylvania. However, like I said, PCADV tracks them. And in the last 10 years, more than 1,400 people have died from domestic violence related incidents in Pennsylvania. Those killed include women, children, and men of all ages, races, sexual orientation, and socioeconomic groups. The most recent data from PCADV is from 2023, and 119 victims lost their lives to domestic violence. That includes 77 females and 42 males, and there were 50 perpetrator deaths. So again, right, what is domestic violence, right? That is the question. And again, domestic violence, and this is really critical to understand, it's a pattern of coercive control that is rarely an isolated incident and involves the use of all different forms of abuse for the perpetrator of the violence to actually assert that control. That can be in the form of physical abuse, right? Most people, when you think of domestic violence, you think black eyes, bruises, right? Because that's what we can see, right? It's tangible, it's palpable. But domestic violence also includes emotional and psychological abuse, sexual abuse, and economic abuse. And they all form what we know as domestic violence. And again, this is the power and control wheel, and I don't know how many of you are familiar with it. It was created in the 1980s by the Duluth Women's Project, and I find it an incredibly useful tool. If you Google power and control wheel, it'll come up, and there's all different iterations. But what's so valuable I find about the power and control wheel is it explains that physical and sexual assaults or threats to commit them are the most apparent forms of domestic violence. But abusers use a whole range of other tactics to assert their abuse over their victims. And the power and control wheel explains these different forms of abuse. And again, as a lawyer, if you're working with a client that you might suspect is a victim of domestic violence, it's important to understand all the nuances. And again, the power and control wheel kind of lays them all out. And abusers may use some of these. Maybe one or two. But again, it's things such as emotional abuse. And I can tell you, because I've been representing victims of domestic violence for over 20 years, I can't tell you how many of my clients have said to me, I wish they just would have hit me. It would have been better than being called fat and stupid and a whore, right? The absolute erosion of a victim's sense of self is such a critical part of the abuse that they experience. Things such as economic abuse, my clients sometimes aren't allowed to work. If they're able to work, they have to turn their paycheck over to the abuser. Oftentimes they have no access to the joint bank accounts. They don't have any credit cards that they can utilize. Or the abuser will say, oh, you know what? I'm going to put the PP&L bill in my name. Don't worry about it. And then they don't pay it. And then it adversely impacts the client's credit score, right? So all of these pieces form the overall pattern of abuse. And a lot of these pieces, the person that's experiencing them doesn't necessarily recognize that that's a form of abuse. And why is that? It's just kind of the way it is, right? And so again, having as the attorney a better understanding of abuse enables you to recognize it. It's also really, really important to know that strangulation is often one of the last abusive acts committed by a domestic violence partner before that person is murdered. If you're working with someone and they say that their abuser choked them, you need to stop. That's a huge red flag. First of all, when people are strangled, they don't refer to it as being strangled. They just don't. They say they were choked, right? Choking is when you eat a piece of chicken and it gets stuck in your throat and someone has to perform the Heimlich, right? However, right, being strangled is when someone typically, usually with their hands, kind of obstructs your airway. So people just don't refer to it that way, right? They're going to say they were choked, right? And they're going to say they were choked in the same way they're going to tell you, yeah, I went to Target. I went to the grocery store. Yeah, I was choked, right? Again, huge red flag. Strangulation is one of the absolute highest indicators of lethality. And so if you're working with a client and they say that, you need to stop. You need to first of all ask if they got medical attention, because oftentimes after someone's strangled, there are no outward signs of the physical impact, but there are oftentimes internal signs that only a medical professional is able to determine. So you absolutely want to tell them to seek medical attention, and you want to let them know the seriousness of being strangled and how that may end in a lethal outcome. So out of control anger causes domestic violence. Myth or fact? Myth? Yeah. But when you hear abusers, they say, I don't know what came over me. I don't know. I just lost it. I lost it. No, you didn't. No, you didn't. Right? So domestic violence, again, is about power and control. It's not about being out of control. Abusers absolutely know what they're doing. It is a deliberate and a calculated choice on the part of the abuser. But what's the abuser going to say to the victim? I'm sorry, I lost it. I had a really bad day at work. I just, I went crazy, right? And, someone who's being victimized is thinking, oh, you know what? I get it, right? I have bad days too. No, 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 no. You also need to understand the batterer mindset, right? A batterer is a person who engages, again, in a pattern of coercive behavior to gain power and control over another. And again, they use all kinds of methods in order to assert this power and control, and it is an absolute choice that they engage in. If it were just that bad, the victim would leave. Myth or fact? Myth. It is a myth, right? But what's one of the first things people ask when they hear that someone is in a domestic violence situation? What's the first thing they think to themselves? Why didn't you just leave? Geez, that would have been me. I would have been out of there. Really? No, no. So because of, again, the dynamics of isolation, the abuser is often the main or the only source of information about the world around them. The abuser is the most important person, right, to that victim aside from their children. And think about it, right? How many of us have been in relationships that maybe like weren't the best, right? And again, the thought of leaving that person or separating from that person, it's devastating. Your life is enmeshed with that person, right? It's not so easy for a victim to just leave. And if you add in the absolute erosion of self-esteem, the isolation, the fact that they've been economically abused, right? What if they don't have a credit card? How do you leave and get a hotel room? You don't, right? You can't do anything without a credit card, right? They can't leave. They can't leave. And that needs to be absolutely understood. And again, the impact on victims, which ranges from emotional impact to physical impact, post-traumatic stress disorder, and again, physical impact. So why screen for DV as an attorney, right? Why? You don't necessarily get taught that at law school. I certainly didn't when I was at law school. So you want to screen for domestic violence to ensure that you're ethically representing your client. You want to avoid malpractice. And again, you want to absolutely provide the best services that you can to the individual that you're working with. And this is kind of a list of some sample questions, right? If you're working with someone who you suspect may be a victim of domestic violence. The other thing you need to think about, and I often say, right, what is an attorney's superpower? What's one of our superpowers? Confidentiality, right? I always like to say, like, that's our attorney's superpower. If I'm your attorney, we have confidentiality, and that's, that's pretty good, right? So you're in a situation with someone who might not have told anyone else that they're a victim of domestic violence, and they might feel a little bit more comfortable opening up to you because, again, you have attorney-client privilege them. You have confidentiality. They know you can't tell anyone. So this is a series of questions you can consider. The first is, obviously, has your partner ever pushed, slapped, hit, or hurt you in some way? Have they ever threatened to hurt you? Again, it's really critical that to constitute domestic violence, you don't actually have to have a physical assault. A threat to harm is domestic violence, and it's protected under the law in Pennsylvania. And again, has your partner ever forced you to do something you didn't want to do? And most victims of domestic violence are also concurrently victims of sexual violence. If you ask a victim of domestic violence, did they ever rape you? No. Rape is something that happens, in the dark and someone jumps out of the bushes, right? Okay, well, when you rephrase the question and say, did they ever force you to do anything sexually you didn't want to do? Yeah, right? Again, we're framing the question, right? That can be incredibly helpful. Is there anything that happens at home that makes you feel afraid? Does your partner prevent you from eating or sleeping or endangering your health in other ways? A really common tactic of abuse is for an abuser to keep their victim up all night. No sleep, right? And they have to go to work the next day. And so I know how I feel when I don't sleep. Like, I am not a nice person to be around. I don't function well, right? So for an abuser to do that, again, it's asserting control over that victim. Has your partner ever hurt or threatened to hurt your pets? We know of the undeniable connection between abuse of animals and abuse of individuals. And I don't know about you, but I love my cat. Right? And we know how important pets are to people. Well, what a great way to exert control over someone than to say, I'm going to hurt your cat. I'm going to hurt your dog if you don't do what I want you to do. Has your partner ever destroyed your clothes, objects in your home, again, or something you really cared about? Does your partner prevent you, again, from accessing financial information? And has your partner ever taken the children from you without permission, threatened to never let you see them again, or otherwise harm them? Again, this is a suggested list of questions to potentially ask someone you're working with. This comes from the ABA Commission on Domestic Violence. It's a tool for attorneys to screen. And so when you're screening a client for domestic violence, you want to let them know that you're asking a series of questions of all your clients, right? You don't want that individual client to feel like somehow you're targeting them, or maybe they walked in the door like blaring, I'm a victim, right? No, right? You also want to explain why you're doing it, right? We know domestic violence is an epidemic. It impacts how you provide representation, and that you can and provide referrals. So again, obviously, first and foremost, let the client know it isn't your fault. Remind the client about your superpower. It's confidential, right? You can't tell anyone else what they said to you. Provide the client with domestic violence resources and information. Do not provide domestic violence counseling. Let me repeat that. Do not provide domestic violence counseling, right? You're not a domestic violence counselor. You haven't had the appropriate training. There's lots of other resources out there. And again, obviously, you're their attorney, right? So you need to talk to them about the impact that the domestic violence may have on their case. In Pennsylvania, there's a Pennsylvania Coalition Against Domestic Violence. Every state has a domestic violence coalition. The PCADV Coalition has resources for every county in the state. Whatever state you're practicing, there is a coalition that will provide free, confidential assistance to victims of domestic violence. Again, I'm an adjunct professor here. If you have any questions, feel free to email me.
Thank you to our panelists. That was a wonderful, wonderful morning. Thank you. And I'm going to turn it over to Jessica Poley and our law review team to open it up for questions.
Thank you. And just a reminder, if you have any questions on Zoom, please put it into the chat and I will read the questions out. Okay. Oh, that's McJunkin.
There we go. This is for Professor Buchhandler-Raphael. I'm really intrigued by your proposal, but I'm curious. You specifically say that the structure of compassionate undercharging should be limited to cases where the abuse is at the time of the crime, right, or contemporaneous with the crime. We know there's a strong correlation between prior victimization and subsequent abuse. We see this a lot in the sex crimes world, right? There's a strong correlation between childhood sex abuse and subsequent acts as an offender. I think Professor Nanasi's proposal showed the relationship between childhood victimization of violence and subsequent violation of law. So I'm just curious why you're limiting it to those particular cases. Is there an argument for a broader interpretation than what you're proposing?
So thank you very much for this question. In fact, this is an issue that I've been struggling myself in the paper. This is still a work in progress. I'm still finalizing it, and I'm going back and forth with precisely with respect to the point that you just mentioned. Because on one hand, I think we have tons of social science research telling us that the effects, the impact of domestic victimization, they don't stop just, after 1 year or two. They could last 20 or 30 years. So there's definitely an argument to basically drop that restrictive element, because we know that abuse lasts for many, many years. And I really do not want to be so, too restrictive. I want to allow more individuals to kind of enjoy the benefits of undercharging. On the other hand, what we do see is, so the elements that I was thinking about, they are modeled after an existing model. And that existing model is the New York legislature, the New York statute, the Domestic Violence Justice Survivors Act. And they do include this temporal requirement. And we have court decisions discussing this temporal requirement. And what they're saying is that when the temporal requirement is part of the law, the New York law, then it's easier to see how the crime that was committed is related, is connected to the past victimization. And that's the significance of the third element, which is contribution to the offense. And then the final reason why I'm still, again, contemplating, but leaning towards including this element is that empirical evidence does show us that there is a link, there is a temporal element, because those women who were interviewed in the California prisons, they committed the crime in the abuse they suffered happened in the year prior to their crime. So there was, in fact, this temporal link. But that's a great point, something that I definitely need to think how I want to limit or avoid limiting my proposal. Thank you.
We have a Zoom question. This is for any panelists, so any of you, all of you. What is the best way for us students and aspiring lawyers to be advocates for individuals who are victims/survivors of DV? Do you have any preferred ways of giving back, specific volunteer organizations to work with?
Well, I can speak. I know there is always a need for pro bono attorneys, particularly in protection court. And so absolutely, legal services office simply can't handle cases. And I can tell you that when a victim of domestic violence has an attorney to represent them in PFA court, they stand a little taller, right? They feel a lot better knowing that they don't have to go up against their abuser alone. So absolutely. Plus, PFA court is nothing if not entertaining. And it's a great way to get your feet wet for being in court, being in front of a judge, and getting some litigation experience.
I think there's another question.
For Professor Buchhandler-Raphael. Do you think that the gender stereotypes for women as being, carrying motherly, that kind of stereotype plays into the lack of compassionate undercharging? And if so, do you think that that needs to be addressed, whether like societally or just within the courtroom itself with the jury, in order to promote that kind of undercharging?
So thank you, Kendra. This is a terrific question. I do strongly believe that stereotypes and biases and prejudices definitely play a role in the way that the criminal justice system treats victimized offenders. And I think so we see for many, many years, as a result of, second wave feminists, we have been taught to believe that women are powerless victims, weak and incapable of leaving their abusers, and men are powerful, strong perpetrators of crime. And I think that's a myth. I don't buy into the power and control wheel. I think it's a very problematic narrative that I don't buy into. So yes, I have looked at cases, especially the cases involving mothers. I see that court sentencing judges and in courts in general treat the mother who kind of deviated from her expected role as a loving, nurturing, weak, and submissive individual. They are punished more harshly. We see women who are, even though the law requires definitely for failure to protect their children, the law in most jurisdictions require a mens rea of not knowledge. We see juries based on jury instructions that they are given. Those women are convicted based on much less, a lesser mens rea than knowledge. But I also think it cuts both ways because we are, educated to believe that women are weak victims and male are powerful perpetrators. The other aspect of that is that we fail to recognize male victimization. So the man, I showed you the slides earlier, there was a man, his name is David Garlock, and he happens to live here in the state of Pennsylvania. He sent me an email and he said, what about me? I'm a victim too. So David Garlock and his brother were sexually and physically abused by an older individual that had connection to their family. And when they were 19 and 21 years old, they killed their abuser. And they were sentenced, charged with murder, convicted with first-degree murder in Alabama, with phenomenal support and help of Brian Stevenson. They both received clemency, and they are now, David Garlock, I'm in touch with him, and he's a completely rehabilitated individual. But I think we have a real problem in, limiting our recognition of who are victims to only those who are, who really comport with this picture that we have in our mind. They have to be weak, they have to be powerless, and we fail to recognize that men fall prey to victimization as well, that some women who are battered do not appear to behave, they don't have the behavior of the victim, they seem to be assertive, and they seem to be violent, and that's when the criminal justice system punishes them more harshly. So that's a great question. Thank you.
My question is for Professor Nanasi. I'm saying that, sorry. Just curious, I know there's some research out there on how long a past crime is predictive of future behavior, like 7 years for a felony. I'm curious if there are jurisdictions within the nation that take that into account and put limitations on those you're not allowed to possess, or if you think that would be helpful.
Yeah, I have firsthand experience with that because in Texas, where I'm from, so I focused on the domestic violence protective order statute, which I should say that prohibition is only valid as long as the protective order is in place under federal law. And I think in all of the states that have that. So once that protective order expires, then you're entitled to get your firearm back. So that's on the protective order front. Under federal law, both the misdemeanor and the felony bans are lifetime bans. But in Texas, actually, just as one example, it's the one I know best, the misdemeanor ban is only 5 years. Now, again, I mentioned there's that interesting interplay, right, of state and federal law. So just because Texas says you get your gun back after 5 years, you still have the lifetime prohibition. But yeah, there are definitely a lot of states that that under the misdemeanor conviction regulation are shorter.
We have time for
my questions for Professor Haynes. You mentioned in your presentation that economics are often a major barrier. And I think it's important because we're training the next generation of lawyers. So I do think they need to understand the barriers as to why people do stay. And I'm thinking specifically around issues involving children and going to school and pets, in addition to economics. Because we want to ensure that we're providing our next generation of lawyers with empathy around this topic, can you speak to some of the significant barriers that do keep people in these relationships, and because that's the reality as to why people are staying?
Sure. Yeah, absolutely. There are so many. First of all, the biggest one is love. They love that person, right? It started off good in the beginning. It never starts off bad, right? And so, people think, I just want to get back to how it was. And I think we can all relate to having gone through relationships that ended and maybe weren't so great. So there's that, right? And, there is the absolute lack of sense of self.
There is the economic abuse. They financially can't leave. They don't have the money to put down a security deposit, first month's rent, right? All of the security deposits that are required. And I know, right? Well, housing has always been a huge issue for victims of domestic violence. And in today's housing market, it is even worse. And so that's a huge barrier, especially you don't want to be homeless. And if you have children, how are you going to handle how are you going to take care of your children? Where are your children going to live? Also, when you have children with someone, you have a vision of a family. And if you leave that person and you take your children with you, you're depriving your children of the other parent. Again, that's a huge barrier, and particularly pets. I know I have a lot of clients that can't leave because they have larger dogs and apartments will not rent to them. Right? Because they can't bring a pit bull. I have clients who have horses. Where are you going to take your horse? Right? Again, so all of these barriers just add up, and it's incredibly overwhelming. And yes, victims of domestic violence can go to a domestic violence shelter, which is wonderful. They can stay there maybe 30 or 60 days. And so the expectation is you've got to figure out all this stuff for yourself and your children, and then you're out, right? After a short period of time. So it's incredibly challenging. We've all heard the statistic that it can take up to 8 times for a victim of domestic violence to finally kind of permanently leave. And it's no wonder why, right? So if I can leave you with any takeaways, if you're working with someone who's experiencing domestic violence, or you have a friend or family member, do not ask them, why don't you just leave? Question should be, why do they keep abusing you?
Thank you. I think that's all the time we have for questions. So thank you to Dean Teplitz and our wonderful panelists.
Can I add just one more thing?
Sure, yeah.
Pinsker. I think, we're focusing on criminal justice responses and policing, and these are all after the fact. These are just tertiary measures. But I think what we're not doing enough in this area of domestic violence is focus more on primary prevention. How do we prevent domestic violence before it happens? And therefore, we need to focus more on the correlates of domestic violence, because we do know that strong correlates of domestic violence are poverty, substance abuse, alcoholism, and unemployment. These are huge correlates to domestic violence. So the reason why many, like Professor Pinsker said, the reason why many do not leave is, simply because they do not want to become homeless, and often they lack employment. So they are financially dependent on abusers. So until we realize that we need to invest in employment opportunities and in financial independence of survivors, nothing's going to change. Thank you.
Thank you. Thank you to our wonderful panelists and Teplitz for moderating. We are now going to take our lunch break, and we will reconvene at 12:30 for our featured speaker presentation. So each presenter will present one after another. We ask that questions be reserved until the end, where we will do a quick 15-minute Q&A session, where questions can be directed to any panelist. There will be law review members walking around with microphones. So allow me to introduce the moderator for our human trafficking panel, Dean Nicole Antos. Nicole R. Antos is the Assistant Dean of Career Development at Widener University Commonwealth Law School. Prior to joining Widener Law Commonwealth in 2022, Dean Antos was Director of Legal and Community Services at the Dauphin County Bar Association. She is a 1999 graduate of the Pennsylvania State University and a 2002 graduate of the Dickinson School of Law of the Pennsylvania State University. Dean Antos is licensed to practice law in the Commonwealth of Pennsylvania and is an active member of the Pennsylvania and Dauphin County Bar Associations. In the PBA, she currently serves as a Zone 3 delegate in the House of Delegates and as a co-chair of the Legal Academics Committee. She also serves on the DCBA Board of Directors and is a member of the Nix Marshall Scholarship Committee of the Dauphin County Bar Foundation. Dean Antos was recently honored by the DCBA as one of the inaugural recipients of the Honorable John F. Cherry Award. She was also selected by the university as a 2024 Widener Pride Personified honoree. Please join me in welcoming Dean Antos.
Thank you so much, Jessica, and to Law Review for inviting me to be a small part of this day and for putting on an incredible program thus far. Our first presenter is Professor Michal Madden-Dempsey, who joined Villanova University Charles Widger School of Law in 2009 after teaching at the University of Oxford, where she was a university lecturer in law and tutorial fellow. Dempsey teaches and writes in the areas of criminal law, feminist legal theory, and philosophy of law. She has served as chair of the American Association of Law Schools section on scholarship and section on jurisprudence. She is an elected member of the American Law Institute and a fellow of the American Bar Foundation. Her book, Prosecuting Domestic Violence, A Philosophical Analysis, published by Oxford University Press, was awarded second prize in the UK's Society of Legal Scholars Peter Burke's Award for Outstanding Legal Scholarship. Her articles have been published by the University of Pennsylvania Law Review, Oxford Journal of Legal Studies, Modern Law Review, Ethics, Criminal Law and Philosophy, Criminal Law Review UK, American Criminal Law Review, and elsewhere. Her co-edited volume, From Morality to Law and Back Again, Libor Amicorum for John Gardner, is forthcoming from the Oxford University Press. Dempsey received her Doctor of Philosophy from the University of Oxford, LLM from the London School of Economics, JD from the University of Michigan Law School, and BA from the University of Illinois. Following law school, she worked as a domestic violence prosecutor in the Champaign, Illinois County State's Attorney's Office, and later as a plaintiff's tort litigator in one of Chicago's premier personal injury law firms. As a civil litigator, she obtained a record-setting jury verdict of $10.62 million in a medical malpractice trial and a $3.5 million jury verdict in a wrongful death case involving a shooting death by Chicago police officers. She remains a licensed member of the Illinois State Bar and a member of the trial bar of the U.S. District Court of the Northern District of Illinois. Dempsey was a tutor in law at University College London and served as an expert consultant on domestic violence prosecutions to the Crown Prosecution Service of England and Wales prior to joining the Oxford Law faculty in 2005. At Villanova, she regularly teaches criminal law, evidence, advanced criminal law and sexuality in law, and has previously taught jurisprudence, feminist legal theory, gender in law, race in law, and domestic violence in law. In 2014, she co-founded the Villanova Law Institute to address commercial sexual exploitation. Dempsey was awarded the Villanova Law Student Bar Association Faculty Member of the Year Award in 2019 and 2021, and was awarded the Diane Ambler Scholarship Impact Award in 2022. And at this point, I will welcome Professor Dempsey on Zoom. And I think Brian is magically going to make her appear.
Okay,
All right.
thank you.
Sure.
Okay, can you hear me okay? You can hear me okay? Yes? Okay, good. Thank you so much for that very long and detailed introduction. I feel like my life has just flashed before my eyes. I'm deeply grateful to be here, and let me start with a sincere apology. I had every intention of being there in person with you all today. Unfortunately, my day exploded in surprising and unhappy ways. So I am delighted to have the opportunity to join you on Zoom, and I'm especially grateful to Jessica for her inviting me, for her flexibility, and for her not having a panic attack when I emailed her 15 minutes ago to ask her if I could join by Zoom. So thank you very, very much. I'm going to share my screen so that you can see the PowerPoint presentation that I'm hoping to share with you. Hold on. Got to start up here, and then I'm going to I'm gonna do the slideshow. Okay, so I believe that I am sharing my slides at the moment. Is that correct? Okay, good. So you can hear me and you can see my slides. We're all a go. Okay, so I have it's a good thing I'm going first in this panel because I'm hoping to sort of frame some of the definitional issues around what we're discussing. So this panel is focusing on human trafficking. I'm going to focus more specifically on sex trafficking because I think that relates more directly to the general topic of legal obstacles in addressing gender-based violence. That's not to say that forms of labor trafficking don't involve gender-based violence, but in part because of my past work and expertise, I am going to just sort of focus our attention on sex trafficking today. So one of the things the main point I want to make in discussing sex trafficking is the inconsistent way in which it gets defined across international law and then national law in the United States. And then I also want to flag up what has been proposed as a model definition of sex trafficking from the American Law Institute with their new model penal code. So why does this matter? Well, it matters. Obviously, we're all lawyers or soon to be lawyers. And so we know that definitions matter, right? And particularly criminal definitions. If you're defining a crime, it's important to respect rule of law values, principle of legality values, and make certain that the definition is as clear as can be. It's also quite important to have a clear, and I would suggest agreed definition of trafficking, both nationally and internationally, so as to facilitate more accurate, reliable, valid, empirical data regarding the phenomena of sex trafficking. There's an awful lot of debate, and I'll get into it toward the end of my talk. There's an awful lot of debate about what counts as sex trafficking. And obviously, when we define sex trafficking as a crime in law, we're making an effort to answer that very question: what counts as sex trafficking and what doesn't? There's also an aspect of sort of how we conceptualize the problem of sex trafficking in our society. There's one side of the argument, to simplify things, would say that for the most part, sex trafficking is mostly coterminous with commercial sex because commercial sex is generally so exploitative that even if there is some small amount of it that's not exploitative, it's a very small amount. And so mostly they sort of travel along together. And then there's others, again, to simplify, at say the other end of the spectrum, who would argue that the sex work can be an empowering way to make money and to live one's life, and that sex trafficking should really be thought of as something quite distinct from commercial sex generally. And those debates and sort of all the interstices between them have generated quite a lot of conflict over the years. So I want to just go over some of that conflict for you. So I'll start with the United Nations Palermo Protocol, which was finally agreed in 2000. That's when the negotiations ended. And it is the very first time that the international community came together to define sex trafficking. And all of the folks who were involved in this debate that I had just mentioned sort of converged on Vienna, Austria, to engage in the lobbying of the representatives at the United Nations who were coming up with this definition. And I know because I was one of them. I was there representing Equality Now, which is an NGO that is closely associated with the first part of the argument that I offered, where they see the commercial sex industry as a whole as exploitative and often violent, coercive, problematic in ways that lead it to want to define the phenomena of sex trafficking broadly, right? So, if you've taken criminal law, or quite honestly, any and torts, or really any law school class, that phenomena can be defined more broadly or less broadly. And so the goal of the lobbyists in Vienna regarding the Palermo Protocol back in the late 90s, leading into the 2000 agreement, was to come up with a definition of sex trafficking that captured a broad range of phenomena. And what I'll do is I'll focus just now on what's called the means elements of the definition. The obviously, sex trafficking also consists of actions. Under the Palermo Protocol, the actions are recruitment, transportation, transfer, harboring, or receipt of persons for the purpose of exploitation, including exploitation of prostitution. So that's the acts requirement and the purpose requirement. But in the middle, there's a series of means that are listed. And it says, if you do any of these acts for this purpose, and you do it via one of these means, then you're committing sex trafficking. And not only is that what we define as sex trafficking, but if your country signs up to this protocol, which the United States has, you commit yourself in Article 5, you take a commitment to criminalize that which has been defined as sex trafficking in the Palermo Protocol. And so this definition, I would say, is quite important. As you can see on the slide here, it includes means of force or threat of force, coercion, abduction, deception, or, and I've highlighted in yellow the sort of key terms I would suggest, abuse of power or an abuse of a victim's vulnerability. So whenever one of these forms, whenever one of these means is used to basically facilitate someone to engage in prostitution, under the Palermo Protocol, it's deemed to be sex trafficking. And whenever one of these means is used, the Palermo Protocol makes it very clear in Article 3B that the consent of the victim is irrelevant, right? So the Palermo Protocol on the whole takes a view of trafficking that isn't about consensual versus non-consensual sex work. Instead, it takes a view of sex trafficking as something that's deeply embedded with exploitation, and that a key part of its wrong-making features are the fact that it consists of an abuse of power or an abuse of the victim's vulnerability. And so I suppose the side that I was there lobbying on behalf of felt that this was quite a win. We were, pleased with this broad definition and this emphasis on issues around power, vulnerability, and including that in the scope of trafficking. Interestingly, however, back in the United States, Congress was also negotiating a definition of trafficking, and it's always been curious to me as to why the two sides weren't talking. But in any event, Congress was negotiating a definition of trafficking as it came up with the original version of the United States Trafficking Victims Protection Act. And it did a couple interesting things. One is that it actually did define sex trafficking to be basically coterminous with commercial sex. But then it just left that definition sitting there in the statute and didn't criminalize that. The stuff that gets criminalized as sex trafficking, which is our concern here today, is different insofar as it requires the use of force, fraud, or coercion. So it's interesting to me that, while the United States is negotiating and pushing for this broad definition that I showed you before, back home, we were enacting a narrower definition. While we were literally committing ourselves under international law to criminalize sex trafficking in all of these broad ways, we decided to just cut two of those ways out of our domestic law. So I am not a federal prosecutor, never have been. In talking with my colleagues who are federal prosecutors and who work on sex trafficking cases, they assure me that the lack of this language has not led to any substantial difficulty in prosecuting cases. It's not as if there are some cases that they would have taken, but they've declined to take because they thought it wouldn't quite rise up to the level of coercion. Instead, what the courts have done in the United States is to define coercion fairly broadly to encompass things that one might think of as an abuse of power or an abuse of vulnerability. So, for example, there is a claim of sex trafficking was made in a civil case, Glagola versus McFan in Pennsylvania, 2023, where the court found that sex trafficking had occurred, based on a tenant's housing vulnerability. So the fact that her landlord basically forced her into sex acts in order to retain her home with her son and to save her and her son from homelessness, she complied with this. And so that abuse of vulnerability was recognized as coercion. And with respect to abuse of power, there are a number of cases that have been prosecuted successfully in the United States where the person who's in the position of the trafficker, the pimp, what have you, controls the victim's access to drugs and thus is abusing that power of having the control over the access to drugs and basically keeps the victim dope sick and needing, in a constant state of being at risk of withdrawal in order to coerce them into sex, commercial sex. And so in some respects, it may be because the courts have been willing to interpret coercion broadly, it captures a decent number of cases. I think there are some, arguments to be said that itself is concerning. If we mean to capture these cases, then we should define them in the law and make it clear that those are the kinds of cases that we want to cover. I want to move on here to the revised model penal code. Now, the model penal code, as I'm sure all of you have had nightmares about, is not a real law, but it is a model law that's been presented, drafted by the American Law Institute. And it, was done back in the 60s. It had sexual offenses provisions incorporated into it. They were pretty horrible on the whole. They were even bad for the 60s. And then as, time marched on, the American Law Institute thought, we should probably revise some of these provisions, like they had a marital rape exception, very, very problematic. Sex without consent was not criminalized back in the original version. So over a very long period of time, at this point, they've not published the final version yet. So I think we may be going on something like 14 years that this project has been going on. But they did finally in 2021 get to a point where they had a tentative final version. And one of the things they did, aside from abolishing bad things like, getting rid of the marital rape exemption and doing some good things like criminalizing sex without consent, they also included a provision regarding sex trafficking. Now, interestingly, they also did not, in the commentaries, they did not acknowledge or speak to our obligation under the Palermo Protocol to criminalize sex trafficking consistently with that broad definition I started with. Moreover, it's hard to say who wrote this, but right, because it's meant to be an American Law Institute group member project. And I actually was a member of that group, although I disagree with many of the things that were done in the final version. So I don't want to attribute this to any particular person, but in the end, the way that it was explained was they thought sex trafficking should just be defined in terms of coercion, which would mean commercial sex without effective consent. And they don't mention in the definition anything regarding fraud or deception. And they certainly don't mention anything about abuse of power or abuse of vulnerability. So, from the perspective of this model penal code that's being offered as a sort of modern take on how to think about sexual offenses, we have quite a constriction. If you look at the Palermo Protocol and all the way to the model penal code, you see over the decades quite a constriction, and we'll see whether any states actually wind up adopting it. But I've kind of compared all of these now. Each line has an X where you can prosecute that case. If you have the Palermo Protocol definition, you can prosecute that case across all of these considerations. But the Trafficking Victims Protection Act limits you, and the model penal code really limits you. For some reason, they didn't even include force, which is particularly questionable. Okay, so that's the sort of survey of different ways of defining sex trafficking. And in the last couple minutes, if I have a couple minutes, I want to speak to some of the concerns that I have regarding inconsistent definitions of sex trafficking as it concerns our ability to do good empirical work on this problem, right? Everyone wants to know, understandably, how big of a problem is this, right? And one of the questions is, what's the prevalence of sex trafficking in any given society? One way to answer that question is to say, out of all the commercial sex that's occurring in this jurisdiction, how much of it meets the definition of sex trafficking? And so obviously the definition you choose will either broaden or constrain the percentage of commercial sex that counts as sex trafficking. And I think some bad empirical research has been done with bad definitions. So I'll just give you a couple examples here if I can. This is Heather Montgomery is an empirical researcher on this topic, and she conceptualizes sex trafficking in an extremely narrow way, such that when she was doing ethnographic work with child prostitutes in Thailand, she noted that there was overlap between trafficking and child prostitution, whereas under any definition, all of the three that I just mentioned, child prostitution would certainly count as trafficking. All of them use 18 as the limit beyond which, or below which, it's certainly trafficking. But she just sees that there's some overlap. So that's, let me see one problem. And then to continue, she writes, I worked with boys and girls between the ages of 8 and 13 who lived with their parents and sold sex on a part-time basis to Western men. She then goes on, these children had not been trafficked, but they had migrated with their parents many years previously in order to do whatever jobs they could find in the tourist industry. And so even though these are children from 8 to 13 who are being bought for sex by Western men, she does not view them as being trafficked, which again is sort of deeply troubling. I'll give a couple examples from a study done in South Africa. And this is from I can get you the citations if anyone's interested, just email me. But a case study of a woman whose name was listed as Sarah, fake name, obviously. While she was under 18 years old, she was forced to remain at a brothel. They spoke to her while she was working at a different brothel. Her previous brothel owner had threatened her with physical violence and threatened to expose her to her family. Now she's 19 years old, so very little time has passed. She's drug addicted and she's selling sex at a different brothel, but they concluded that she was not being trafficked. And whereas I would look at Sarah's case and say, well, that seems like an abuse of a position of vulnerability. The mere fact that she turned from 18 to 19 doesn't sort of wipe away the vulnerability that she has from the experience of being trafficked when she was younger, and also the drug addiction that she currently suffers from. Another case study in the Gould and Fick study is what someone they call Chantal. She's described as hungry, drug addicted, and engaging in street prostitution, in which, quote, she couldn't turn clients away. And so despite acknowledging that she had no autonomy to turn clients away, they categorized her as not being trafficked. And the reason why they did that was because they said, well, she hadn't been forced or induced to do the work by a third party, and she could stop at any time. It's like, well, if she couldn't turn clients away, she really can't stop at any time. And it's not that sex trafficking requires the use of force. Force is one of several means by which trafficking can be accomplished. And it's particularly vexing that Gould and Fick claim to be following the Palermo Protocol definition in doing this study. And, I can send this article to you, but it's basically, it created quite a problem in South Africa because people who wanted to liberalize the commercial sex industry and sort of have the law step back at all from regulating it or prohibiting it for fear of sex trafficking were eager to prove that sex trafficking wasn't really a problem in South Africa. And so Gould and Fick's study was really seminal to making that argument. But when I would contend that when you look at the study, you see that they're really misusing and butchering the definition of trafficking. I'll give I think this is the last example. Xing is trafficked in China from China to South Africa. She had been previously trafficked in China. She spoke no English, but they said she was working 13 hours a day, 6 days a week at a brothel that kept 65% of her money. So not only did they define this and categorize this as non-trafficking, But they also, just in terms of their methodology, they gave no explanation of the translation process, any compliance with human subject research ethics. They literally were just calling up brothels and saying, hey, are you trafficked? And when they got this information, they categorized it as not being trafficked. So I will stop the share. Okay. So I hope what I've done in about 15 minutes is to sort of give a range of different ways of defining sex trafficking and pointed to some of the reasons why it's important to get a good definition. For my money, I would stick with the Palermo Protocol definition, but I'll be interested to see what my co-panelists have to say. So thank you very much for your time.
Thank you, Professor. Okay, our next panelist is also joining us via Zoom. Rachel J. Wexler is an associate professor of law at University of Missouri School of Law and an affiliate faculty member in the MU School of Social Work and MU Department of Sociology. Professor Wexler previously served as a research fellow at the Zimroth Center on the Administration of Criminal Law at the New York University School of Law. Her research focuses on gender-based violence in the criminal and family legal systems. Her interdisciplinary work reflects her background in law and social science. She holds a doctorate in criminology and a master's degree in evidence-based social work, both from the University of Oxford and a JD from the University of Pennsylvania Law School. Professor Wexler's scholarship has appeared or is forthcoming in the University of Pennsylvania Law Review, the Boston College Law Review, the Washington Law Review, the Fordham International Law Journal, the British Journal of Criminology, and Theoretical Criminology. In 2024, Professor Wexler received the Jordan Hoyt Memorial Tribute to Women Award from the University of Missouri Chancellor's Committee on the Status of Women, the Balance of Justice Award from the Student Bar Association, and the Carrie Mae Carroll Award from the Women's Law Association. Professor Wexler served as the Associate Director of NYU's Lawyering Program from 2019 to 2020 and is an acting assistant professor from 2017 to 2020. In this position, she received NYU Law's Podell Distinguished Teaching Award in 2020. Previously, she was the 2015 McDougall Visiting Professor of International Law at the West Virginia University College of Law, where she taught international human rights law. And I believe I saw her on the screen and the PowerPoint is up, so I will turn things over to Professor Wexler.
Thank you so much for having me, and I'm sorry I can't be there in person with you all today. But I really do appreciate the opportunity to speak with you about my research and a topic that I'm really passionate about. And I also look forward to hearing the questions after all of our presentations. So I'm going to be talking to you about my research and my forthcoming paper called The Non-Punishment Principle and Restorative Justice. So when it comes to human trafficking victims, social scientists have referred to them as a hidden population whose size and boundaries remain unknown despite our best efforts. But one place where we can certainly find them is in our nation's jails and prisons. So this phenomenon directly implicates a legal norm known as the non-punishment principle. At its core, the non-punishment principle opposes the punishment of human trafficking victims for criminal conduct they engage in connection with their trafficking victimization. So the origins of this principle actually can be traced back to something Professor Dempsey was talking to us about, which was the Palermo Protocol, which was negotiated in 1999 as part of the UN Convention Against Transnational Organized Crime. And was enacted in 2000. So the non-punishment principle has been interpreted to be included as part of the Palermo Protocol, which is the protocol to this UN convention that specifically focuses on addressing human trafficking and It's the most major and largely enacted binding international legal instrument addressing human trafficking specifically. And there have been meetings among the state parties since, called the Conference of States Parties, and they have, meet regularly to talk about the interpretation of the obligations under the Palermo Protocol, and they have interpreted Article 2B of the Palermo Protocol, which obligates states to protect and assist trafficking victims, to include the non-punishment principle. And that has most recently been acknowledged in, I believe, 2022, but it's also been recognized before then. So since its incorporation into the Palermo Protocol, the non-punishment principle has been incorporated into a significant number of both soft law and binding legal instruments on human trafficking at the international level, and also at the regional level and domestic level. And so at the international level, we have binding legal instruments, the Council of Europe Convention Against Human Trafficking, EU law, ASEAN, which stands for the Association of Southeast Asian Nations. They have an anti-trafficking convention that incorporates the non-punishment principle. And there have been an abundance of soft law instruments, including UN, Security Council and General Assembly resolutions from the Organization of American States, Council of Europe, etc. Other intergovernmental bodies have recognized the non-punishment principle in their in soft law instruments that they have promulgated. But today I'm going to be focusing on its instantiation within US law at both the federal and state levels. And then after I talk about my survey of US law, I'm going to discuss my proposal to employ restorative justice to address harms that result from crime committed by trafficking victim defendants when there are cognizable victims in a way that I believe is more effective and aligns more with the non-punishment principle than current approaches, which are often very limited and restrictive. So first, at the federal level, we see the non-punishment principle reflected in a couple of federal statutes that have recently been passed. And the articulation of the principle, it sounds like it's pretty broad. These laws require that Department of Justice and Department of Homeland Security law enforcement personnel be trained in the non-punishment principle. And it articulates the principle as victims of sex or labor trafficking often engage in criminal acts as a direct result of severe trafficking in persons, and such individuals are victims of a crime, and affirmative measures should be taken to avoid arresting, charging, or prosecuting such individuals for any offense that is the direct result of their victimization. So one of the main issues with this is that in 2017, when signing these laws, President Trump, during his first term, issued a signing statement that I believe is going to really circumscribe the potential impact of the non-punishment principles within these laws. And in the official statement released, which is identical for both of these laws, specified that his administration will interpret this non-punishment provision, quote, consistent with the prosecutorial discretion of the executive branch and the president's constitutional responsibility to faithfully execute the laws of the United States. So this signing statement really suggests that the implementation of the non-punishment approach to human trafficking victims at the federal level is likely to be quite limited. And we do also see, given the how rapidly the president's administration has been implementing its really strict approach towards immigration, it, I think, raises certain questions and doubts about whether the DHS officers are doing proper screening in a way that would even allow them to implement the non-punishment principle, as this law states. So the non-punishment principle also is articulated as a congressional finding in the TVPA of 2000, which has since been reauthorized multiple times. And this interpretation has been used as the basis of the US's position at a federal level in representing the US to the Conference of States Parties, to the Palermo Protocol, and in and also in policy guidance and discussion. So I've added the bolded language here because I think it's particularly important. This congressional finding states that victims of severe forms of trafficking should not be inappropriately incarcerated, fined, or otherwise penalized solely for unlawful acts committed as a direct result of being trafficked, such as using false documents, entering the country without documentation, or working without documentation. So inappropriately really leaves a lot of discretion, and also raises questions about what, how limited and how narrow the implementation of the non-punishment principle is, and if this actually has any sort of impact on whether trafficking victims who are engaged in criminal conduct, whether they're actually protected from criminal prosecution and punishment. So there's also the non-punishment principle also has a distinct presence at the state level. And with the help of my wonderful research assistants, we engaged in a survey of the 50 states plus DC, looking at the following instantiations of the non-punishment principle, looking at immunity and affirmative defense statutes that are specific to human trafficking victims, looking at statutes and judicial initiatives that provide for diversion of people identified as victims to human trafficking courts, prostitution courts, treatment programs, and social services, and also looking at the non-punishment principle has been interpreted at both the international and the federal level, and at the state level, as also extending to post-conviction relief and post-sentencing relief. And that's where vacator, expungement, and sealing statutes based on trafficking victimization come into play. But due to time constraints, I'm actually going to just share restrictions related to offense type. So even though most states have at least some forms of the non-punishment principle in their laws, there are very commonly restrictions based on things like offense type, only certain minor offenses that trafficking victims commit being eligible for non-punishment principle application, or the nexus that's required between the victimization and the criminal offense, whether how tight that nexus is, that required nexus is. And also sometimes there are statutes that only apply to juvenile victims, but adult victims do not have the protection. And so I'm going to share a small part of our results based on restrictions regarding offense types. And if anyone, I have about 7 different maps in this paper. It's not yet up on SSRM, but I'm happy to share a draft with anyone who emails me if you're interested in seeing more of the data. But here's just for one example. These are restrictions based on offense type, and these look at age unrestricted statutes, so applicable generally to both adults and juveniles. So as you can see from the map, 23 states, including Pennsylvania, where you all are now, limit trafficking victims' eligibility for an affirmative defense based on their trafficking victimization to only prosecutions for prostitution and prostitution-related crimes. So that leaves, trafficking victims who commit other types of crimes unable to benefit from the protections of the non-punishment principle. 7 other states restrict it to all nonviolent crimes. And also importantly, it is not uncommon for trafficking victims to be involved and to be charged with trafficking other victims, because traffickers will often coerce their victims into recruiting new victims or controlling new victims. But only 13 states permit a trafficking victimization-based affirmative defense to be raised in prosecutions for human trafficking offenses. And just 4 states, Oklahoma, South Carolina, Wisconsin, and Wyoming, allow a trafficking-based affirmative defense to any crime. I'm going to skip this. There are a few states that provide extra protection for juvenile victims. So the overall bottom line of my data is that even though there's a distinct presence across the country of the non-punishment principle, it's often very restricted and limited, often premised on this dichotomous characterization of people as either victims or offenders, and without an appreciation of the victim-offender overlap that often exists within human trafficking situations. And often this categorization is done based on whether victims present in a way that meets with certain stereotypes, present as fully passive and fully cooperative with law enforcement, for example. And there's the question of when you do have serious crimes, what do you do when someone's been really harmed due to a crime that was committed by a human trafficking victim defender? And I know that I'm running out of time, but there's one example to just give the bottom line here. Yvette, who was prosecuted in Texas for robbery and trafficking of a minor. Her trafficker brutally beat her and abused her and threatened to hurt her family if she tried to escape, and coerced her into engaging in these crimes. She was in Texas, she could only raise the defense to prostitution related crimes. So she wasn't able to benefit from it. She also wasn't able, she froze up when she tried to testify against her trafficker during trial, and the prosecution took any deal off the table. And so she was convicted of sex trafficking a minor and robbery that occurred within the context of her trafficking situation. And she's currently serving a 23-year sentence in Gatesville, Texas. So just very briefly, I propose that we look to restorative justice when, as a way to address serious harms that might arise, such as in the case of Yvette, as a non-punitive way to address this harm that comports with the non-punishment principle. And I believe that restorative justice does have the flexibility to account for the nuances within the trafficking dynamic, including coercion, abuses of power, abuses of a person's vulnerable position, resulting in that person's diminished culpability, and also navigate the victim-offender overlap in an effective way while still respecting the non-punishment principle, and in a way that is aimed at addressing harm and understanding harm and repairing harm that has occurred when there is a victim of a trafficking victim defendant. So I'm happy to talk more about this during the Q&A, but I want to I'll just end there for now, and thank you so much for your attention.
Is Chief Deputy Attorney General Heather Castellino. Heather is a career prosecutor and has served in the Pennsylvania Office of Attorney General since 2000. In January 2024, Heather was appointed to lead the first statewide human trafficking section at the Pennsylvania Office of Attorney General. Prior to this appointment, Heather worked as a prosecutor in the organized crime section. She began her career as a deputy district attorney in the Bucks County Office of the District Attorney. Since 2008, Heather has been prosecuting human trafficking cases. She has coordinated, prosecuted, and tried numerous human trafficking cases, working with the Pennsylvania State Police Organized Crime Unit, agents from the Pennsylvania Office of Attorney General, local municipality police departments, and the Department of Homeland Security investigations. These cases have resulted in multiple convictions in both state and federal court. Heather has presented on the subject of human trafficking at many conferences, symposiums, CLE presentations, and law enforcement trainings. She has also been invited to and has participated in the presentation of case studies highlighting successful prosecutions of large-scale national sex trafficking organizations at international conferences. Prior to her career as a prosecutor, Heather received her bachelor's degree from Temple University in political science and her JD from Villanova Law School. I'll do that first. Please bear with me.
All right, thank you to the dean. Thank you to Jessica for organizing this, and thank you to everybody for hanging in there for the last presentation on the afternoon and on a Friday. So I'll also say that reading the bio, hearing my own bio makes me sound way cooler than I think I really am. I'm going to talk today specifically about Pennsylvania law and human trafficking. So all right, a little bit about the Attorney General's office. I think it's something that some people are familiar with, but others aren't. So just to put in context where I am and what I do, we're a statewide agency. We have jurisdiction over certain crimes in Pennsylvania. The district attorneys have jurisdiction over any crime in Pennsylvania within their region. So we're not like a super DA's office. And I say that because what's relevant to my current job is that we did not have jurisdiction to prosecute, to investigate or prosecute human trafficking cases until 2018. So for young people, that seems like it might've been a long time ago, but really in the context of us doing these cases, it wasn't. We started investigating and working on these cases back in around 2009, and we did it in the context of what we call the corrupt organization statute in Pennsylvania, which most people are familiar with as the RICO statute federally. Just last year, we started a human trafficking section in the AG's office. So we are getting some more resources to continue to do these cases and also expand from doing sex trafficking cases also into doing more labor trafficking cases. So I caught some of DA Steele's presentation when he was talking about, I wish I could have seen all of it, but the couple slides I saw could have been like cut and paste into my presentation. And I have very similar ones because a lot of the myths I think are very similar in rape cases and in sex trafficking cases. Also, there's also a crossover in labor trafficking, but particularly sex trafficking. So one that I think was very similar to what he was talking about is an adult can be considered a victim of human trafficking even if she consented to the sex act. So what does that mean? I'll get to the law in a little bit, but just kind of keep that in mind. A minor cannot be a prostitute. So prostitution is still a crime on the books in Pennsylvania. That's a word that those of us investigating and prosecuting these cases and working with survivors of human trafficking try not to use. But the reality is it's still a crime in Pennsylvania. So you could be charged as an adult for engaging in a commercial sex act, which is basically sex for money. If you're under the age of 18, you cannot consent to engage in sex for money. So if you have sex for money with somebody under 18, that's sex trafficking, period. You don't have to prove anything above and beyond that. Here's another myth. Many victims, what the myth should be is that they want to cooperate with law enforcement. And this, I think, myth is one of the biggest things we have to deal with as investigators and prosecutors in these cases, because I think the media has portrayed this image of people coming in, swooping in and rescuing people that have been waiting to be rescued in whatever situation they are in. Unfortunately, that's not how it works. It's a lot more complicated than that. One of the biggest things I like to talk about with people is, I know the movie Taken's getting kind of old, but I think most people are still pretty familiar with it. I refused to watch it until last year, and I can now say that I've seen it and I still hate it. It perpetuates every myth we have to overcome when doing these cases. Does that happen the way it did in Liam Neeson's movie? Probably, yes. Is that a super small percentage of what's going on and what we are focused on? Yes. Another important point that I'm going to throw out there before I get to the law is the concept, and this is something that we could talk about for like an entire panel, but the concept of the demand for commercial sex fueling sex trafficking. So why is that important? Well, there's a lot of reasons, but it's a basic, and I'm not a math person, I'm a career prosecutor, but it's a economist, but it's a basic supply and demand issue. If nobody was buying sex, there wouldn't be any commercial sex, and therefore there wouldn't be an opportunity for traffickers to commit the crime of sex trafficking. I think we're starting to realize this as a whole of investigators and prosecutors more and more in Pennsylvania. There's more and more investigators and prosecutors charging the buyers, which a lot of people use the slang term Johns, for purchasing sex, to try to address this problem in a different way. Something I'll throw out there that you can look up on your own if you're interested, but the penalty and the charge for buying sex is extremely minimal. It's almost the equivalent of a traffic ticket. So it's right now not much of a deterrent in Pennsylvania, whereas selling sex, if you're the individual actually performing the act, is a more serious crime and a higher charge. So it often results in the victim of sex trafficking being charged and penalized at a much higher rate than the buyers. Something I throw out there because this might not be something that people in this room or on this Zoom might think, but in my everyday life, when I talk about this, which I probably do too much, is people confuse human trafficking and human smuggling. Smuggling is a crime against a border. So if you come to one country illegally across the border and someone is helping you do that, you're being smuggled across the border. Trafficking is a crime against a person, exploitive, right? So smuggling is a federal crime, and sometimes it goes hand in hand with trafficking, but human trafficking doesn't require any kind of movement. You can have an entire case of human trafficking happen out of one house, and that victim or survivor is never moved out of a room. Another thing I like to point out there is a lot of victims and survivors, particularly children, are trafficked by people that they know, which is another issue that we talk about because it creates a mindset that people are expecting to hear when we present these cases to them as a judge or a jury, is people are expecting to hear that a kid was kind of swept up in the Target parking lot or at the mall and brought to some place they don't know and then exploited. Again, that happens, but that's not what happens most frequently. There are, and when I first heard this a few years ago, I was shocked. I think it's absolutely shocking that there's a significant amount, and I don't have the actual statistics, but they're out there, of children being trafficked by their own parents. So this is specifically the Pennsylvania law, very similar overall to the federal law that my co-panelists talked about a little bit, but I'm going to focus on what we call Chapter 30 under the Pennsylvania Crimes Code. And right up front, the law comes right out and says that there's three primary goals, which I think are all very important, especially for other law enforcement and prosecutors to think about. It's not just prosecution of human traffickers, but it's also prevention of human trafficking and protecting the victims and survivors. And it's broken down by those pieces as we get further into the statute. So Title 18, Section 3011 is the actual sex trafficking. A is the actual sex trafficking portion of the statute. It's entitled Trafficking in Individuals. And it's a long, wordy definition, and I'm not going to read the whole thing. But basically what it says, it's a felony of the first degree if you commit a certain act for a certain purpose and it has a certain result. And we heard a little bit already in this panel, and I apologize, I don't remember which of my co-panelists said this, but talked about acts, means, and purpose. And I'm going to talk about that a little bit more here. But before we do that, labor trafficking is a felony of the second degree. So it's treated a little less serious, but still the second highest grading of a crime in Pennsylvania. And they come right out, the legislature came right out and said, in case it wasn't really clear to everybody, but sexual servitude of a minor occurs whenever sexual conduct or performance involving sexual conduct of a minor, regardless of force, fraud, and coercion. So this is probably kind of small for everybody to read, but the basic idea here is the act, means, and purpose. And for me, that's a very helpful way to think about what is sex trafficking or what is labor trafficking. So first you have the act. So the trafficker has to either recruit, entice, harbor, transport, provide, obtain, advertise, maintain, or solicit, or knowingly benefit from those things. So you could be the person actually committing those acts, or you're just benefiting financially from those acts. I have highlighted there, and I don't know if you guys can read it, but patronizes was also added into 3011A1 and 3011B1. So I'm sorry, just 3011A1 because it relates to sex trafficking. So what that means is if we can, as prosecutors, can prove that somebody's buying sex and basically they knew or should have known that the person they're buying sex from is being trafficked, they can be charged with a felony of the first degree. That's a fairly recent amendment, which I hope is going to be a useful tool for us in the future. So again, the means are not necessary if you have a minor, and the purposes are either sexual servitude or involuntary servitude. I have a little graphic on the side because it helps me formulate the way some of these organizations work, because a lot of the cases we've found have been some type of organization. It could be just one person or two people at the top, but there's usually other people helping to facilitate that trafficking, whether it's sex or labor. The sex traffickers often have facilitators. Like, what does that look like? Drivers driving the victims from wherever they're living to the actual quote unquote date or the commercial sex act. There can also be sometimes enforcers to keep an eye out that the victims aren't doing things they're not supposed to do. And then of course you have the buyers. So the federal statute that we heard a little bit about says force, fraud, or coercion. In Pennsylvania, we break that down to be a little bit more specific. And so there's 12 means by which you can subject someone to involuntary servitude. And the first three, I think, fall under a force category. So threatening or causing serious harm to somebody. Okay, that's easy. Physically restraining or threatening to physically restrain someone. Again, that's easy. And the third one, kidnapping or attempting to kidnap any individual. I know I'm just one person and one prosecutor, but I like to throw out when I'm talking about this, that of the 12 means, number 3 has been the least common that I've seen in the cases that I've worked. So 4 through 7 are different forms of fraud. And we talk about them in a much more specific way in Pennsylvania. So abusing or threatening to abuse the legal process, that's an easy one. For labor trafficking, usually it could be for sex trafficking too, but that's when a trafficker takes advantage of any part of the legal process. Probably the most common and the most talked about right now is immigration status. The trafficker says, if you don't do what I tell you to do, you don't work the hours I tell you to work, I'm going to call ICE. Another way that we've seen traffickers manipulate their victims through threatening to abuse the legal process is, unfortunately, a lot of the victims and survivors have been exposed to the criminal justice system, have been charged with crimes. A lot of times it's related or because of their trafficking, but the traffickers know that. The traffickers say, well, you're the one who's doing something illegal. You're engaging in sex for money. You're the prostitute. I'm going to expose you for the crimes that you're committing. Engaging in unlawful conduct with respect to documents. That could be as simple as taking someone's driver's license or their green card or anything else that they might need to exist. Extortion and just fraud. And there is no specific definition for fraud under Chapter 30, so it's just generally a common sense definition. And coercion. Coercion is a specific crime under the Crimes Code. Duress through the use or threat to use unlawful force against a person or another. And it caught my attention during one of my co-panelists' discussion regarding threatening. I think it was at the very end with a woman who was charged with trafficking and is serving a lengthy sentence. One of the things that struck me was that the trafficker used her family as a target. And I've seen that over and over again. A lot of the victims and survivors that are being subjected to sex trafficking have children that the traffickers say. It could just be as simple as like, I know where your kids go to school. I mean, if you're a parent, you can understand how scary just that statement is. Debt coercion, and that's sort of self-explanatory. Facilitating or controlling the individual's access to a controlled substance. We see that a lot. Am I going out of time? Sorry. Okay, sorry. We see that a lot. It's a trafficker either specifically recruiting an individual who's already addicted to a controlled substance or getting someone addicted to a controlled substance and then limiting their use to that and controlling it. And 13 is really a pattern of a lot of the other things that we've already talked about here. So sorry if I went over. Am I okay? All right, but I think I'll leave it there. The rest of my slides, or a lot of the rest of my slides, were actually going to address the specific things in Pennsylvania that we do, and I actually wrote this down, that involve the non-punishment principle, which I didn't know was the actual term for it until today. So if you're interested, you can look at the statute, and we have some of those protections already in PA.
Thank you so much. It is interesting how everything is so intertwined. And at this time, if anyone on Zoom has questions, you can put those in the chat, and Jessica is going to come back and field questions.
All right, we can open it up to questions for any panelist.
So thank you everyone for wonderful presentations. I have a specific question for Professor Wexler. I was curious for your thoughts about the limits of the non-punishment principle. And in particular, how far are you willing to expand the non-punishment principle? And there's one specific case that I have in mind, but there are many cases like that. I think the non-punishment principle is easily applied when the crimes that are committed by the survivors are not extremely violent or kind of minor crimes. But what happens in cases like, there's a very famous case from Dallas, Texas, the Zeffie Trevino case, in which, and many others, one in Wisconsin, Crystal Kaiser, in which survivors of sex trafficking commit very serious crimes. They kill people as a direct result of being trafficked. So the question is, are we willing as a society to say these survivors, offenders are not punished at all, or instead think that their the level of their criminal responsibility should be reduced, but we should not completely free them? That's my question. Thank you.
Thank you so much for that question. And I also appreciate all of the helpful comments you've given me on my paper. So I can only speak for myself. I can't speak for society as a whole, but I do believe that restorative justice is a meaningful way to address harm, even in the cases of serious crimes. I didn't really get too much of a chance to talk about restorative justice, but I think there are a lot of myths about it out there. So personally, I do think it is appropriate in the case of serious crimes committed by trafficking victims. Just a few basic fundamentals about restorative justice to potentially dispel, I think, some of the myths about it being very soft on crime. Even though it's non-punitive, it meaningfully addresses crime in terms of the process, which is a long process with an expert facilitator who first works individually with the person who caused harm and the person who experienced harm, using the language of restorative justice, to prepare them to come together and join in dialogue. There are often community members who are involved and support people, both the person who caused harm and the person who experienced harm. And the more serious the harm, typically the much longer the process is. And so the goal of this process, first, individually and then bringing people together, is to figure out what the victims or the victim's loved ones need, and how, and to also understand the harm, how to understand how the harm happened, which is often very overlooked. Like in the case of Yvette that I was talking about, we're talking about serious harms. The victim of the robbery was injured very seriously, and I believe that restorative justice would be a meaningful way where, and usually this process yields an agreement that has concrete steps for the person who caused harm to do everything possible to try to make the harm right. But in the case of Yvette, the jury never heard anything about her victimization. That was completely kept out. And restorative justice allows for an appreciation of how this harm actually occurred, and an understanding of that, and also efforts to prevent the harm from happening again, which also involves efforts to prevent Yvette and other people like her from being re-trafficked and from being re-victimized. So I'll leave it at that, but my personal position is that restorative justice is an appropriate response, even in cases of serious harm.
Other questions? Oh. Go ahead, Professor Dempsey.
Okay, I don't want to preempt anyone in the room. Is there anyone in the room who has their hand up?
No, you're okay. Go
Okay,
ahead.
all right. So thank you, Professor, for that question. And actually, Rachel, I want to follow up on it. So I think it's easy enough to get on board with restorative justice in a case like the one you described, or in a perhaps a whole universe of cases where the crime we're dealing with is one that was perpetrated by a victim as a result of their victimization. What do you think what do you think the role is for restorative justice on the flip side, so for traffickers themselves, and in particular in cases where the traffickers are not acknowledging what they've done? They're not acknowledging the harm, the wrong that they've committed. So I'm thinking, I mean, he hasn't been convicted, so I'm not saying anything, but if someone named Andrew Tate was guilty of some of the things he's been accused of, he doesn't seem to be a good candidate for restorative justice. And I'm not sure what we do with people like that.
Well, I do think for restorative justice, the person who has caused harm has to be willing to acknowledge it in order for them to be a good candidate for that, and has to be willing to genuinely engage with the process. I don't think there's a bar to having traffickers involved in restorative justice. And restorative justice is flexible enough that it often comes into play as diversion early in a process, but it can also be a process that people engage in later on. Even it doesn't have to be my proposal, in order to respect the non-punishment principle in the case of trafficking victim offenders, to have it as an alternative to punitive sanctions, incarceration. But restorative justice is often used, in other situations in a way that either mitigates a punishment or something that doesn't affect things like a length of incarceration, but that somebody who has caused harm is ready to reckon with it and wants to engage in the process. And one of the reasons why the facilitators, ideally you want a very experienced, a very knowledgeable and experienced facilitator. A restorative justice facilitator works with people separately before bringing them together. And part of that is to make sure that they're able to engage in the process in the way it's meant to happen, in a way that prevents additional harm from occurring.
Thank you, Professor Wexler. I actually believe that's the end of our question period, unfortunately. Does anyone have any other questions before we go? Okay, well, thank you all for coming. Thank you to our moderator and our wonderful panelists. I appreciate you guys attending. I am now going to turn it over to our editor-in-chief, Miranda Thompson, to give some closing remarks. Thank you.
Thank you, everyone, and good afternoon. My name is Miranda Thompson, and I'm the editor-in-chief of the Widener Commonwealth Law Review.
As we come to the close of this incredible symposium, I want to take a moment to extend my thanks to our wonderful speakers, our thoughtful moderators, and our attentive audience, as well as all of the individuals that have been recognized in the remarks throughout this event. But I do really need to emphasize and thank the work of our Pennsylvania Law and Symposium editor, Jessica Poley. As early as January last year, she had a vision for bringing this discussion to life through the Widener Commonwealth Law Review platform, and her hard work and passion for change is the reason we are all sitting in this room today. So thank you. The passion and expertise displayed before us today should remind us of the importance of having these conversations. And I recognize that these are difficult conversations, but we all have to start somewhere, and starting meaningful conversations is the first step toward change. The Widener Commonwealth Law Review has been so privileged this year to host 2 symposia, both with a focus on reinvigorating human rights discussions in our community. However, this step forward would not have been possible without the support of Dean Cummings. I approached him very early with our vision of what we hoped the Law Review could accomplish, and although he may be tired by now of my many asks, he has stood by us all the way and allowed us to create a space for these dynamic discussions. With that said, I am honored to introduce and welcome Dean Cummings. Thank you.
Do not have a long speech planned, but I do want to say a couple of things. I think it's critical at a law school to have hard conversations. If you were at the Dean's Diversity Forum, you heard a hard conversation about DEI. If you were at the original Law Review Symposium in the fall, we had conversations about systemic racism, both in the past and continuing. Today, we talked about sexual violence and trafficking and really difficult conversations, but that's what we should be doing. And we should be doing it because if we're going to resolve these difficult issues, we have to put our minds and our intellect behind figuring out ways to resolve these solutions. So I really want to congratulate Jess for a wonderful Law Review Symposium today. Thank you so much. I want to thank Professor Michal Buchhandler-Raphael. She has devoted so much of her time and energy and work to these hard issues. And there are controversial issues, as we've learned today. And it's not always easy to be out on the forefront talking about controversial things. And yet Michal is willing to put her voice and her intellectual power behind something that means so much and is so meaningful to her, and helped Jess with organizing this event today. And so I want to thank Professor Michal Buchhandler-Raphael. Those of you Law Review students know that your editor-in-chief is a force of nature. I met Miranda before I was even dean here at the law school, and she's been pushing me before I started and ever since to be able to have real meaningful content here at the law school. I'm really grateful to Miranda for her leadership, for her ability to bring tough conversations to the table, and I'm sad to see Miranda go. She's also my research assistant, one of my research assistants. I'm sad to see her go. But I have no doubt that she will have a very successful career. And so I want to acknowledge Miranda and her leadership of the Law Review as well. Finally, our Law Review is in good hands. I was delighted to learn that Kira Flannery was elected editor-in-chief for the incoming class year. Kira, I'm expecting just as incredible work from the Law Review next year going forward. And I know you have a whole bunch of stuff to publish that's been accepted this year. But I will finish by saying this. I am so grateful to be able to be the dean at this excellent law school. I am impressed constantly. When I meet with our alumni, I'm startled by how fantastic and successful they are. When I sit in some of your professors' classrooms, I am so impressed with how well our faculty teaches, and I can't wait to see how well our 3Ls do with bar boot camp starting shortly today, as well as the bar exam coming up. But I also want to thank all of the panelists that joined us. We collected people from around the United States to talk about this incredible issue. And so thank you to those of you that participated today in what was a invigorating and important conversation. So let's decide today that we're going to go forward, that we're going to do something meaningful that's going to make change. We can write articles, we can advocate, we can do our work, but believe me when I tell you, after 25 years of being a practicing attorney and an academic, you can get stuff done. And you can get it done because you feel it and you recognize how important it is to put your efforts behind meaningful work. And whether that's in transactional law, criminal law, domestic violence, sexual exploitation, defending, prosecuting, real estate, whatever it is, you can be phenomenal in that work. You can provide incredible service to your people, your clients, and you can make differences, particularly to those folks that don't have the ability to voice for themselves or represent themselves in the way that we can. That's what we are teaching you to do, to be able to lead and to represent on a going forward basis. So that's all. Thank you so much for being here. And let's once again thank everyone for this fantastic event.